Yes.
May I please, your Lordship? Lordship, I need some accommodation with respect to item number 6, Lordship.
6.
It's,
Yes. What is your prayer?
Prayer, Lordship, I adjourn the matter for today, Lordship, and fix it after 4 weeks, Lordship, any date in the month of possible April.
April.
April, Lordship. I have some problem, Lordship. Yes,
You have to make alternative arrangements because
uh,
you're going to pursue otherwise.
it's a arbitration matter, Lordship.
I know.
That day, both parties has problem.
No, but you can't.
Last month or
I
last.
can agree that you are not. You have some health issues. 1 week, 2 weeks, 3 weeks is okay. But
4 weeks, Lordship. March, end of March, Lordship.
the end of March.
Actually, it may take long deliberation, Lordship. The Patak.
No, we have all the time. Who says we are short of time?
No. I have some. That is it.
We'll have it on 19th March. 19 March.
Okay.
On the request
Okay.
made by the council for the petitioner, Mr. P. Sharma, matter stands deferred to be listed on 19 March. We are not oblivious of your discomfort, but the problem is that if you want to pursue the matter, it requires
Lordship,
a
actually,
hearing.
it happens. It was not my control, Lordship. That.
No, we are not saying that. We are saying that if you want to pursue the matter,
Lordship.
either you have to make yourself
I will
available
make
or
some
make
alternative. If I'm not able, I will make alternative arrangement, Lordship.
Right. All right. Get well soon.
Okay. Apply still.
May it please, my lord, prayer for listing of our admission matter as per your lordship's convenience. Next week, any day.
My convenience will be in March,
My
9th of March.
my lord, next week, my
You said my convenience.
my
Next week.
Right.
Next week, 13th.
deeply obliged.
May please, well, I am mentioning for listing of a matter for admission on 16 May. Some interim order they have filed.
16th.
May please, your lordship. I beg to mention for listing of the motion matter, your lordship, on 9, your lordship.
9.
Nine.
When did you file it?
File on 28, your lordship,
December, January.
January.
All right, 9th.
Mashallah.
Why is it not listed? Some defects.
Defects, no, if it is defect, then I may correct it, but no any indication,
All right, 9th.
just lying. Mashallah.
Your Lordship, praying for a motion matter for tomorrow. This matter pertains to your Lordship. Actually, yesterday it was listed before Honorable Court number 4, your Lordship, but wrongly listed because that a matter of bench 5, your Lordship. So
What is the
for,
matter?
the election of Lordship, for the post of General Secretary of Assam High School Teachers Association, your Lordship. Earlier also I mentioned before this Honorable Court, but stuck in between court number bench 2 and bench 5, your Lordship. For that reason, your Lordship, it got stuck in that way, your Lordship. So for tomorrow, your Lordship.
Why not on Monday? Let it be on Monday, 9th.
Monday, Lordship.
9th.
Lordship.
I'd like to mention, my lord, contempt petition, my lord. The settlers are,
Contempt petition.
yes, my lord.
9th. 9th.
May it please your lordship. Lordship, I'm praying for listing of this matter in the motion column, lordship. It was filed on 21/26, lordship. On 9, lordship.
21,
Lordship, 20/21, lordship.
26. It has not been listed.
Lordship.
Press matter.
Trace matter, lordship.
All right, 9th.
Obvious.
May I please, lordship, I beg to mention for a withdrawal of the writ petition, lordship.
Tomorrow.
So tomorrow, lordship. I know.
May I please, your lordship, I beg to mention for listing of this writ petition earlier in terms of the lordship interim order passed by this honorable court. Though lordship FEDCL authority has not inclined to provide the electricity connection, but subsequently when this matter was listed on 5/1/2026, they have provided the temporary electricity connection, but today morning they have disconnected, not even given the opportunity, lordship, to extend the temporary connection, lordship.
So, Monday.
Highly administrative.
My pleasure, Lordship. Lordship, I would like to
can
mention
it
for
be on,
listing of a
Tuesday,
writ
Lordship?
petition.
Not Tuesday. Monday or Wednesday.
Wednesday, lordship.
All right, Wednesday. 11th.
Lordship, I would like to mention for listing of a writ petition civil for tomorrow's.
Why?
It is a eviction matter actually.
Writ petition for what? Motion, admission,
So for listing for
for motion, admission,
Yes, sir.
orders, hearing,
Motion.
what? Is it as a freshly filed matter?
yes, sir.
When was it filed?
21st of January.
Let it come on 9th.
So, actually, Lordship,
You have waited from 21st January. You can wait for another 2 days. Let it come on 9th.
Lordship, the eviction, for vacation is on 12th of February.
You filed your matter on 21st of January. Please tell us what has happened since 21st till today. Why is the matter not listed? Did you make a mention earlier before the court?
No.
Why were you waiting for making a mention till tomorrow or today? Let it be on 9th. All right? Yes.
May please, Lordship praying for listing one motion matter.
9th.
Lordship, on 13th of February.
You want it on 13th.
Yes, Lordship.
Freshly filed.
No, Lordship.
All right, 13th.
May it please your lordship. Lordship, I beg to mention for listing of a rate petition, lordship, for orders.
For orders. 16th.
Lordship, after 16, give the date after 16,
18th.
obliged lordship.
May please, your Lordship, I beg to mention for listing of a IA for correction of an order, Lordship. Tomorrow,
Monday.
Monday, much of that.
Lordship, with the consent of the other parties, Lordship, I would like to mention item number 3.
3.
Lordship, and
What is your prayer?
we are praying for an adjournment, Lordship.
Yes, Mr. Surya.
Yes, but better maybe later on 24th of March, my lord.
24th of March.
Yes, my lord.
Why?
My lord, I have some problem.
Oh,
That's why, my lord.
your problem is on 19th.
9,
9. All right. 24th.
24th, my lord.
24th of
Father hearing.
March.
Lordship.
For further hearing.
Obliged, my lord.
So item number 2 and 5, joint prayer, Lordship, matter can be listed after 2 weeks.
2 and 5.
Yeah.
Joint request be listed after.
There's
2
an
weeks.
interim in 2 and 5, Lordship.
Interim orders, Mr. Lee will continue.
Much of
Obliged, Lordship.
Supplementary list for motion method sale.
Mr. Agarwal, why after so many years? 23?
23, Lordship.
He has no business at all since
Yes, so let him start
2023.
afresh. Why does he go back to the earlier one?
Some payment are yet to be received by the petitioner, therefore he has filed a petition, Lordship. Only, and he has already submitted all the returns on December 2025, Lordship. And any tax amount penalty required to be paid, he will pay, Lordship.
Similar orders.
Lordship,
Page number 33.
Lordship.
Yes, Mr. Jain.
Lordship.
I heard clear counsel for parties disposed. Similar orders, page 33. Okay.
Much of that. May please, your Lordship.
That is balance.
Yes.
The petitioner herein is a life convict, your Lordship, and he is behind the bar, lodged in, continuing his sentence since 30/8/2008. And in the month of December 2025, he had a stroke. And thereafter, he was admitted in GMCH on 12/12/25 and released on 16/12/25. Then his emergency leave was granted by order at 7/1/26, which is at annexure number 2, your Lordship, page 14. Command certificates and all other documents, your Lordship. And his emergency leave is about to end on the 6th of this month. And therefore, the family members of the petitioner made an application under Rule 20 of the Assam Prisoners Emergency Emergency Release and Leave Petition. Rule Leave and Emergency Rule 1968, your Lordship. But initially the application was not entertained, hence we are before this honorable court. But there are some development yesterday, your Lordship. The petitioner was again admitted in the hospital and another petition was made under Rule 20 and the authority are telling to come today for consideration of the same.
No, I'm not. You're on parole.
Yes, your Lordship.
So where is the order granting you parole?
Annexure 2, your Lordship, other command certificates and all others. Annexure 2, page number 14 onwards.
So you are required to appear on 6/2, it is already
Yes.
there.
Yes, Your Lordship, but I was admitted again in the hospital. And for that reason, I was paralyzed by the right side.
We are not on that. Then after that, when did you suffer your the medical ailment?
The earlier one, in the month of December.
December.
Yes,
When was this parole issued?
7th January,
Of
2026.
7/26.
7/1/26.
7/1/26.
And it ends on 6th this month.
Then what happened after that? What happened?
Thereafter, on 28th, we made an application before the jail superintendent, but that was not initially entertained.
Hmm.
Therefore, we were before this honorable court by way of this.
Where is that application?
That is at page number, Your Lordship, 25, page number 3, Annex 3, page number 25.
Hmm.
But that was not entertained initially, stating that there is no such rule. But there was a latest development.
Where are the medical documents in
Mm,
support of this?
That is Annex 4, Your Lordship.
Annex 4 is a prescription.
Prescription and thereafter certificates. And he was admitted from the jail by the jail authority initially, Your Lordship.
Now, what has happened on this application?
That was not considered, stating that there is no any rule. But subsequently, yesterday, there was a recent development. The jail authority called my brother and asked him to make another application. And we have submitted the application with the latest medical documents.
When?
Yesterday, Your Lordship.
Yesterday.
Yesterday. That is not on record. Okay. That is.
So what has happened? What, Mr. Sharma?
Just now I came to know regarding this, Lordship, but normally in such type of cases, Lordship, I do not want to argue, but he has not annexed the relevant documents, Lordship. In paragraphs number 6, he has specifically stated that he was admitted to the Guwahati Medical Hospital, but Lordship, he has annexed the private doctor's prescription.
That is also, he was admitted by the jail authority, Your Lordship.
No, Lordship, the only
that
paragraph 6, Lordship.
I mean,
So
His health condition was deteriorated and he was admitted again in the Guwahati Medical.
So you have to get your instructions here.
Lordship.
So, but he's supposed to report tomorrow.
day after tomorrow. 6, sorry, yeah, tomorrow, Your Lordship.
But he is directed to submit certain documents along with the relative
Your Lordship,
today.
Page
What
number
happened?
23, if Your Lordship means.
Lordship may fix it tomorrow. Let him get that instruction. I will also try to get the instruction.
Page
What
number
happened?
23, Your Lordship.
Yes.
It's the letter of the superintendent, jail superintendent. I have the honor to inform you that convict so-and-so was diagnosed with so-and-so and the medicine department of GMCAS so-and-so, in fact, with type 2 diabetes and so-and-so. It was the letter from the
Type 2
judge.
diabetes and hypertension, Lordship.
And cardiovascular accident, CVA, which is equivalent to stroke, common name.
No, but we need the information. Where were you treated in the
Yes,
GMC?
I can produce the documents.
It's not a question of you can produce.
Yes, but
It's a question of
Lordship.
supporting documents on the basis on which you are making your submissions.
yes,
Why, if you have not produced, the question is why have you not produced and why should we indulge you? You are asking for what is the prayer that you
That's
have
it.
in the writ petition?
my prayer is simple, that consideration of my application, and till then I may be allowed to stay with my family.
You will direct it today, we'll close it today, let them consider it.
Lordship, by
But
tomorrow.
is there any prescription under the rule? That application like this, what rule are you referring to?
Rule number 20
Of
of Assam Prisons Leave and Emergency Release Rule, 1968.
Is it available in jail manual? Police manual? Police manual আছে?
এখনো নামটো
Assam Prisons.
এইটো আসাম প্রিজন্স লিভ এন্ড ইমার্জেন্সি এইটো আছে
20.
Which rule?
Rule 20, Your Lordship.
Firstly, show us where is the procedure of emergency release?
Rule number 14, Your Lordship. flag marked.
Innocent authority may subject to the provision for invents emergency. This was followed, Lordship. He was released on parole for 1 month, Lord.
So under 20, he has already applied. So we close this petition directing them to consider and pass appropriate orders.
If the prisoner remains released.
Or-
But Lordship, if your Lordship
Or
comes
we
to
give
this,
them, we give the department a leave, saying that in view of the applications pending, read with Rule 20, let them consider pendency will not
but
be a bar.
Lordship may I please that rule 14.
14 years.
Yes, Lordship. This is regarding to facilitate the inmate's presence, as your Lordship got it.
Correct.
Rule 14.
To facilitate the inmate's presence in his family during a period of grave emergency like death or serious illness of father, mother, brother, sister, spouse, and children.
Mm.
He, according to the petitioner himself, Lordship suffering from so Lordship medical treatment will be given by the jail authority themselves.
Mm.
This emergency release is for that only.
No. Come below. Number
To
2.
facilitate attending the marriage ceremony of his daughters, sons, brothers, and
No.
sisters.
Before that, number 2.
Number 2 is the Lordship. I think that is an old one of the.
There is one more to facilitate the inmate. I do not know. It is available here.
But in this book, Lordship,
You have a look at this. দেখুন, did you?
To facilitate inmates in specialized treatment for diseases like surgeon opinion prison surgeons to be approved by the civil surgeon. To facilitate the inmate in specialized treatment for diseases like tuberculosis, cancer, etc., in accordance with the opinions of the prison medical officer to be approved by
But
the
this
civil.
this is to evade. This is not emergency leave. This is under Rule 8 and Rule 7. Doesn't refer to Rule 14. Page number 14.
My learned friend is referring to pay.
This command certificate you say is emergency leave.
Yes, your Lordship.
Is not emergency leave.
Rule
This is
8
to
and
avail
7.
leave for 30 days.
Yes,
With
it is
effect
only
from
on
so
parole.
and so, read with Rule 8.
Yes, your
and
Lordship.
Rule
7
7.
and 8. Your Lordship.
This is not Rule 14. This is not Rule 14.
My mistake, your Lordship.
So your mistake means there is no scope for extension under Rule 20. Rule 20 is not even applicable.
But your Lordship, may I direct to consider my
No.
application?
Why should we? Show us a rule. Where is Rule 7 and 8? Sounds it up.
I do.
Tell me now, page number whole अपना 67682. হয় না পাইছে না? Procedure for application at page 674. Rule 7.
That is procedure, your Lordship.
7.4, one copy of the application shall be retained in the office of the censor, and 8, grant of release on leave. Grant of release on leave. Page 676. If on receipt of the recommendation of the district magistrate, the Inspector General of Prisons is satisfied that there is no objection to grant the leave applied for.
If you come to the definition,
Yes, sir.
there is a distinction between emergency release and leave.
Yes, your Lordship.
One is not equal to the other.
Yes, your Lordship.
Therefore, you were given leave, not emergency leave.
Yes.
Why did you address the court that it is emergency leave?
He shall make an order for release of the prisoner on leave for 20 days in case of first release or 30 days, because these are subsequent releases. Because of that 30 days parole was given to you.
There is no provision for extension of leave. There is no provision here. There is no provision.
Yes, Your Lordship.
So we are dismissing your petition. Or you want to withdraw it?
I will withdraw it.
Heard counsel for parties, the application has been filed by the petitioner seeking a direction to the respondent authorities to consider his application for seeking emergency leave. The counsel for the petitioner submits that petitioner was granted emergency leave by way of the command certificate issued on. When was the command certificate issued? There's no date.
Seven one to
7-1, Your Lordship.
7/1/2026.
Your Lordship.
The by way of the command certificate, the petitioner was granted annual leave with effect from 7/1/26 to 5/2/2026 under Rules 8, read with Rule 7 within bracket Roman 4 of the Assam Prisons Leave Rules 1968.
Your Lordship, may I submit one thing?
Hmm.
Page number 16, Your Lordship.
Hmm.
There is a personal bond in there along with annual leave. There is the line, word emergency leave also mentioned. Page number 16, Your Lordship, typography, type 1.
Where is the original copy?
Original is page 18, that is not clear, Your Lordship, but it can be read, second para. And whereas the Inspector General of Prisons Assam has been pleased to release me on annual leave / emergency leave for the term of 30
This
days.
is a bond executed
Yes,
by
yes,
you.
yes,
By you.
yes,
And if you come to the original copy at page 18,
yes, Your Lordship.
emergency leave is struck out.
That is not clear here.
This is struck out
Yes, Your Lordship.
at both places. So therefore, this is only for annual leave.
annual.
And this is nothing but a bond executed by
Yes, yes,
you
it is a bond.
that you will come back and present yourself on 6/2.
Yes, Your Lordship.
কি লিখিলা? Not emergency leave, annual leave. By order with effect from so and so. And he was directed to surrender before the Superintendent Central Jail Guwahati on expiry of the annual leave on 6/2/2026 or on recall. He was released from the jail on 7/1/2026. Then he, in pursuance to the command certificate, he was released on execution of a bond on 7/1/2026, whereby he had undertaken to present himself on 6/2/2026 upon expiry of the annual leave. Stop thereafter. Petitioner on submits that he suffered on 29/1/2026. He filed an application stating that he suffered. He has been admitted in GMCH for treatment on left. He filed an application on 29/1/2026, wherein he stated that he had suffered from stroke in the month of December 2025 and was required medical treatment in the GMCH. So he has been convicted for life and he had been in jail for 18 years. And on the ground of medical emergency, he was released on parole. And by the said representation, an extension was sought for under Rule 20 of the Rules of 1986 for extension of the leave or emergency release of the convict on the ground of ongoing medical treatment. Lord, the said application is supported by prescription and a certificate issued by Dr. Pritam Goswami, MBBS. So, since his application was not considered, he has filed a writ petition before this court. Upon examining the enclosures to the writ petition, it is seen that by way of the command certificate, dated command certificate, petitioner was granted annual leave for a period from 7/1/26 to 5/2/2026 under Rule 8, Red with Rule 7(4) of the Assam Prisons Leave Rules 1968 and the government notification dated 3/9/2014. Stop. The petitioner went on leave on being released from the prison on 7/1/2026 in pursuance to the command certificate and on the execution of a bond on 7/1/2026, undertaking to present himself on 6/2/2026. Stop. Petitioner has raised his history of medical ailment that he had suffered in December 2025, i.e., which is well prior to the leave granted by the jail authorities and the extension of which he has sought for by way of the present application. Stop. The representation filed by the petitioner before Inspector General of Prisons under Rule 20, although refers to the medical ailment he had suffered in December and stating that further treatment is required as a consequence of the ailment he had suffered, was filed under Rule 20 of the said rules. So, perusal of the rules revealed that definition section Rule 2A defines emergency release as so and so, and Rule 2C defines leave as so and so. Rule 4 lays down the criteria when prisoners shall not be granted leave or release. Rule 5 prescribes when petitioners are not to be released. Rule 6 prescribes eligibility for leave. And Rule 7 lays down the procedure for the application. Stop. Rule 8 lays down the procedure on the basis of which the grant of release on leave is to be granted. Stop. It also prescribes that a bond as prescribed in the form as Appendix capital D for such amount as may be ordered by the Inspector General of Police is also to be executed, and which was duly executed by the petitioner when he was released on leave by the command certificate. Stop. Rule 14 relates to emergency release. Stop. Rule 15 to 18 and 19 lays down the procedure for obtaining the conditions of emergency release. That's it, right? Stop. Rule 20 is a provision for extension of the release, the emergency release. Stop. It provides that if the prisoner on emergency release requires extension, he may apply for the same to the authority sanctioning the emergency leave. Stop. There are, insofar as the leave prescribed under the rule is concerned, Rule 6 provides that subject to the provisions of Rule 44, eligibility for leave for 20 days in case of first release and 30 days in case of subsequent release shall be governed as shall be regulated by Appendix A.
May I please one thing, that 14(2), that was deleted by a notification, Lordship, regarding that
Okay.
to facilitate the inmates to specialized treatment.
Yes, yes,
That was deleted by a government notification.
Okay. Yes. Under such circumstances, it is seen that under the Assam Prison Leave Emergency Rules, there are two categories of leave. One is the leave per se, and the other is emergency release. Both are governed by separate provisions. The provision for extension of leave appears to be related to only emergency release as prescribed under Rule 20. So, but under such circumstances, the submissions made by the counsel for the petitioner that he was given emergency release by the command certificate dated with effect from 7/1 so and so to 6/2/26 does not appear to be correct. The petitioner was not granted emergency leave, he was granted leave as per the prescription of the rules. And the petitioner is required to present himself before the authorities as per the bond, as per the undertaking executed in the bond, on 6th of February. He is required to present himself before the authorities on 6/2 as per the undertaking in the bond executed by the petitioner. Stop. Under such circumstances, at this stage, this court is not inclined to issue any directions to the respondents as straightforward. So, although the medical document is shown to be enclosed, and a certificate which reflects that the petitioner had suffered from is suffering from post-stroke complications. However, in the representation before the authorities, it is seen that the petitioner had been treated in the GMCH on 16/12/2025, whereas the medical documents which are enclosed to the petition are perhaps from private practitioners and not from the GMCH authorities. Be that as it may, we don't find any. We don't on the basis of the submissions and the facts urged, this court is not inclined or does not find any merit to warrant any directions, issue any directions to the respondents. However, the dismissal of the writ petition shall not be a bar to the authorities to consider the application which the petitioner submits has been filed yesterday.
Yes, sir.
And if the authorities find that it is as per rules, appropriate orders accordingly may be passed. Writ petition stands dismissed.
Deeply obliged.
That cannot be considered, Lordship, under that.
Daily list for admission, I think, last.
May please the Lord. In this matter, the petitioner was enrolled as a rifleman in the Assam Rifles Council. And he was awarded with the extreme form of
This
punishment.
is what Pathad matter.
The part of it.
We release it now.
Lordship?
Was it heard extensively?
Yes, Lordship.
What is your case?
I was dismissed from Lordship service for submitting Lordship, for false matriculation certificate at the time of Lordship enrollment, Lordship. And imprint order is at page 20, Lordship. And our honorable court, our division bench judgment is also there in similar line, Lordship. I have placed that also before your Lordship. In earlier occasion, Lordship.
This is for what? This is bigamy.
And
Division
is
bench
for-
is
that is
bigamy.
bigamy. But the provision in that also statutory provision was there for dismissal. In that bigamy also. Though in my case, it's Lordship, the provision is dismissal is there, but some
This will require, we'll have to refresh our memories.
Lordship.
What is it?
It may come to face.
What is the judgment of the, there's another division bench judgment, you were,
Yes, Lordship.
two judgments.
Yes.
You're referring to two judgments.
Two judgments, but the second division bench judgment, Lordship, that realized the initial one.
This is on bigamy.
There is in bigamy.
Both the judgments are bigamy.
Both are on bigamy. One is from CRPF, another is from CISF. But my case is of Assam Rifles. And in both those cases, Lordship, the bigamy is the punishment is dismissal from service.
Now, in your case, what happened? Why did you submitted false documents?
Lordship, because of Lordship poverty, I appeared before verification. I appeared in the matriculation examination, but result was not out, Lordship. So, Lordship, but I qualified in the that test of the for recruitment, Lordship. So one of my relatives, yes, got some fraudulent documents, Lordship, and he submitted it. Then I was supposed to submit the original documents once I get it, Lordship. I passed also. Before joining, I passed the matriculation also, but subsequently, due to Lordship, due to fear that I may be removed, I did not, Lordship, join. Thereafter, for 10 years, Lordship, without any break.
What is your right? Tell us that.
My Lordship, right is Lordship,
You are before the writ courts.
Yes, Lordship.
You have to urge your right.
Yes, Lordship.
What is your right and how is your right violated?
In my Lordship, humble submission, it's the extreme form of punishment is because
Extreme form of punishment is on a sympathy.
Lordship. Lordship, sir.
You can't say that extreme form of punishment has taken away your right
Lordship.
of being considered fairly.
Lordship, but there are some provisions that the lenient view can be taken in the provision also, law also. Lordship, may I draw your attention to Lordship, page 20 first, Lordship.
2020.
20, Lordship. This is the order, improved order, Lordship, paragraph 6, last, Lordship. Now, therefore, in exercise of the powers conferred under the provisions of section 11(2) of the Assam Rifles Act 2006, read with Rule 17 and Rule 22 of Assam Assam Rifles Rules 2010, I hereby dismiss you so and so. So he has been dismissed under these provisions. Lordship, may come to the Act, Lordship. 11(2). Section 11(2).
You admit that these are false documents. What else is there?
My Lordship, that Lordship they may consider that because of this is the extreme form of punishment. Not only me, Lordship, I will not get the civil service also, and my all family members, they will also suffer. That has been discussed in that judgment, Lordship, and relying on that only, Lordship. And there is not only the dismissal, removal, or Lordship, the compulsory retirement can be also be done because I have discharged service for 10 years, Lordship, without any blemish,
So
Lordship.
does it make you eligible for pension?
Compulsory, Lordship, that it is
10
converted.
years? You
Lordship.
need how many years of service?
10 years.
10 years.
10
So
years.
he's completed 10 years.
No, 9 years, 11 months.
And then how does it, supposing we modify it into compulsory retirement or
At least all the more, at least civil will get some job in civil also, Lordship. Because nothing otherwise dismissal word, Lordship, he is restricted from getting any job in civil also. Civil consequences also.
that we will say that this order shall not act as a bar in ensuring re-employment in the civil sector.
Lordship.
Shall not be read as a bar. That we can see.
Yes, Lordship, that can be done because
If that is the only thing you want, we can say that.
or they may consider if the authorities, if they consider that.
If towards the rule,
Yes.
the provisions of the act.
Yes, Lordship, 11(2), Lordship may come to 11(2), the provisions.
Section.
Yes, section 11(2).
Assam Rifles Act,
Assam Rifles Act.
11(2). Yes.
It says the 11(2). 11 dismissal, removal or reduction by Director General and by other officers. And 2 speaks about an officer not below the rank of Deputy Inspector General may dismiss or remove from the service any person under his command other than an officer or subordinate officer of such rank or the ranks as may be prescribed. So this is the person who can dismiss. Now Lordship may come to Rule 17. Rule, Assam Rifles Rule 17.
Rule 17.
Yes, Lordship.
Yes.
Yeah, Rule 17 speaks about let's say, termination of service. That's it. Authorities specified in the heading of column 3 to 6 of the table given below shall be competent to dismiss, remove, discharge, retire, or release a member of the force specified in the column 2 on the grounds stated in the corresponding entries in column 2 in accordance with the procedure laid down in this chapter, and any power conferred by this rule or any provisions of this chapter on any of the aforesaid authorities may also be exercised by any other authority superior to it. Now, Lordship may come to the table below, Lordship. These are the at table below serial number 4. This is the furnishing for false or wrong information at the time of enrollment, Lordship. So for this rule says, Lordship, the dismissal, there may be the provision says that the authorities may dismiss, remove, discharge, retire, or release, Lordship. So I am praying for let's say a lenient Lordship punishment, so that Lordship on the basis of
On what ground? Give us grounds.
he has Lordship served for 10 years, but they
That
didn't
is not
raise,
a
they
ground.
did not raise any objection to that, Lordship.
No, that is
But
not a
at the
ground. It was incumbent on you. You know that you have submitted false documents.
but Lordship in the
It is not a case.
yes.
This is not a case that you applied for your given documents through the proper channel,
Lordship.
but somewhere some documents were misplaced or wrong documents were served and you were not aware. It's not a case like that.
Okay.
You knew on the day when you submitted that these are false documents
Yes. But
and you are
Lordship-
asking for leniency. You are a member of discipline force.
Yes, Lordship. But Lordship, I also, it is not the case that I have not the required requisite qualification.
That is a different issue.
At the time of verification, I did not have.
You did not have, but subsequently
yeah,
you say you did not make an attempt to place it before the authorities
Because-
for the fear
Yes, Lordship. Yes.
that you are going to lose your job,
Ye-
and which was in which case also
No.
it would have been well within the rights of the authorities, because you cannot get a job by submitting false documents.
Lordship is correct.
And as you know, the qualifications are the qualifications which you have on the date when you make the application.
Lordship.
You may have sat for the exam.
Yes, Lordship.
On a day when you apply, you did not qualify.
Yeah, Lordship, it is
You
correct.
did not qualify, somebody else would have qualified. You could have applied in the next
Lordship, I am praying
recruitment process.
in terms of this, our division bench judgment. Lordship, may
The
come to-
division bench judgment, according to me, with all respect, is not applicable. That is in a case of
Lordship, may-
bigamy.
Yes,
That is
Lordship
in
may
a case
come.
of bigamy.
There also, Lordship, in my humble submission, in bigamy also, the provision is for dismissal.
No,
But
that-
the
that-
lenient view
that is all right. But in bigamy, the provision is that if there is a complaint lodged by someone,
Yes, Lordship.
by the wife,
Yes.
or by someone that
Someone.
he is having a second wife, then
Lordship.
it is up to the authorities.
Lordship.
Here is a case, you knew on a date of recruitment you were not qualified.
No.
Yes,
Yes, Lordship.
you knew that you are submitting documents which are not genuine.
Lordship.
Yes,
Lordship.
and you continued for 10 years
Lordship.
on the ground that they did not ask for genuine documents. Is it their responsibility to ask for genuine documents, or is it a responsibility on you?
It is on the petitioner.
Then that's the end of it. There's no question of leniency here. We
Lordship.
don't find any infirmity with the order passed.
Lordship may peruse on my submission that peruse para 9 of the judgment, Lordship, once again. Lordship.
With judgment.
Of the division bench judgment, writ appeal, Lordship.
There are two writ appeals.
The writ appeal number 357 of 2020.
Yes,
Lordship.
Para
Paragraph
9.
9, Lordship.
yes.
May I read, Lordship?
Hmm.
Dismissal is the most extreme form of punishment which can be imposed upon a government employee, which has the effect of not only cutting the source of income, thus depriving him and his dependents of the means of sustenance.
So that we are ready to give you. We are saying that we will reject your appeal, but with a rider that this dismissal order shall not operate as a bar in re-employment in civil.
Lordship, Lordship,
That's all.
Lordship.
But we are not going to modify with this.
Yes, sir.
Third, learned counsel for parties, this writ petition is filed by the petitioner. Essaying the order dated 23rd of September 2019, whereby the petitioner who was employed as rifleman within bracket general duty in the Assam Rifles, the 7 Assam Rifles, was dismissed from service for furnishing false and incorrect information at the time of enrollment. Stop. The petitioner was enrolled into the Assam Rifles on 19 October 2009. Stop. At the time, during the recruitment process, he submitted a high school leaving certificate examination and mark sheet issued by the Board of Secondary Education, Assam, Guwahati, in order to make himself eligible for the recruitment process. Stop. In terms of the materials and documents submitted, the petitioner was recruited into the Assam Rifles, and he thereafter was employed in the 7 Assam Rifles as rifleman general duty. Stop. He rendered his services for about 9 years.
11 months, 11 days.
11 months, 11 days. Stop. Subsequently, on a verification process undertaken by the Assam Rifles, relevant documents were sought for from the personnel, including the writ petitioner. Stop. During this verification process, it was found out that at the initial recruitment, during the process of initial recruitment, the documents submitted by the petitioner relating to high school leaving certificate examination and mark sheet stated to have been issued by the Board of Secondary Education, Assam, Guwahati, were found to be false and forged. Stop. Under such circumstances, was any proceeding undertaken?
Show cause notice.
Show cause notice as per rules of Assam Rifles Regiment.
Did he reply?
Yes, my lord. He pleaded guilty also, my lord.
A show cause notice was issued to the petitioner, to which he replied and pleaded guilty. Stop. There is clear admission that the petitioner had submitted false and forged documents at the time when the recruitment process was undertaken and when he was enrolled as a rifleman general duty in 7 Assam Rifles. Stop. The petitioner, counsel for the petitioner attempted to persuade the court that it is not a case that the petitioner did not have the requisite qualifications, namely his high school leaving certificate, and had successfully cleared the class 10
Subsequently,
examination.
after his enrollment.
Stop. At the time when the recruitment process was undertaken, he had appeared for the examination. However, the results were not declared. Stop. Under some mistaken and wrong advice, petitioner procured some documents and submitted before the authorities. Stop. He was subsequently selected and recruited as a rifleman general duty. Stop. However, for the fear of losing his job, the petitioner did not present the genuine documents which he procured later after due completion of the class 10 examination. Stop. The matter remained thus till when the evaluation and re-verification of the documents were undertaken by the Assam Rifles Authority, when it was discovered that at the time when the petitioner had applied for recruitment, and when he was recruited into the Assam Rifles, the documents submitted by the petitioner, namely the board of the high school leaving certificate and the mark sheet of 2006
And
issued by the Board of Secondary Education Assam Guwahati was found to be false and forged. Under such circumstances, the authorities initiated the inquiry proceedings by issuing a show cause, pursuant to which the petitioner had replied and pleaded guilty. So there was no further hearing.
No, man, because that
In-
is the procedure as per rule only to give some.
In view of the clear admission, the impugned order dated so and so was issued whereby the petitioner was dismissed from service. Stop. Para. Mr. Tobildar, learned counsel for the petitioner, has placed before the court two judgments of a division bench of this court rendered in Trilok Singh Rawat and
Read appeal number 357/24. Then
Oh, no,
initial one is
no.
a single bench.
writ appeal number so and so, reported in so and so Jodi ki Dasya. The learned counsel for the petitioner, by placing reliance on the judgment, submits that although the facts of these cases pertain to bigamy. However, the division bench of this court has held that where other forms of punishment are prescribed, ordinarily dismissal being the harshest form of punishment ought not to be considered as a first ground of punishment. Stop. He therefore, and in both the matters, the dismissal was converted to
Compulsory retirement.
compulsory retirement, was modified and converted to compulsory retirement. He submits that this case, the facts of this case, considering the genuine, considering the fact that the petitioner had, in the meanwhile, acquired the eligible criteria and qualifications, his case was also required to be considered leniently by the authorities, and any other form of punishment instead of dismissal from service ought to have been issued. Stop. The punishment of dismissal, besides the petitioner losing his employment, will also lose all benefits and will also render himself unfit for further employment in any sector, including civilian sector. So under such circumstances, the present writ petition has been filed, and prayer before this court has been made that the punishment of dismissal be interfered with, on the matter be remanded back to the authorities for reconsideration, and or in the alternative, this court may consider modifying the punishment, altering the punishment of dismissal into any other form of punishment. Yeah, alternative to nullity, sorry. Stop. MS Gayan, Learned CGC, submits that there is no denial by the petitioner that he had submitted false documents. There is a clear admission in the reply submitted by the petitioner in response to the show cause notice issued to the writ petition. Stop. Therefore, the authorities had taken the action as contemplated under the Act read within this. The judgments pressed into service as it relates to bigamy does not are not applicable to the facts of this case. Where having heard learned counsel for the parties, and upon careful perusal of the pleadings, it is seen that the allegation made against the petitioner is that he submitted false high school leaving certificate examination and high school leaving examination certificate and mark sheet for the relevant years issued by the Board of Secondary Education, Assam. So there is a clear admission by the petitioner in his reply to the show cause notice issued. Under such circumstances, the authorities considered the case of the petitioner and did not find his reply sufficient, and accordingly passed the impugned order dismissing the petitioner from his services. Stop. The judgments which are pressed into service essentially are in respect of matters where the delinquent officer was found guilty of bigamy. Stop. And under such circumstances and under the facts of each case, this court had considered that the dismissal from service would be in the most extreme form of punishment and was therefore not called for in the facts of each of these cases. Stop. Similar prayer is made in the present proceedings. Stop. This court is of the view that there is no dispute with regard to the facts urged in the present case. Petitioner submitted false documents at the time of recruitment and at the time he was enrolled as Rifleman GD. Stop. This fact was known to the petitioner and he deliberately submitted these false documents, knowing fully well they were false and knowing fully well that on a date when the recruitment process was undertaken and he was given the enrollment, these documents, he did not possess the genuine documents which made him eligible to be qualified for participating in the enrollment process, the recruitment process, and getting the enrollment in as Rifleman GD. Stop. Although subsequently the petitioner acquired the qualification, fact remains that these were never placed before the authorities concerned, and the petitioner continued to render service for 9 years, 11 months, 11 days. When in a verification process undertaken by the Assam Rifles authorities, this defect was detected and consequently proceedings were undertaken. Show cause notice was issued, to which the petitioner submitted a reply clearly admitting his guilt, and as a consequence thereof, the impugned order dated so and so was passed. Stop. There is no quarrel that it is not res integra today that a person is considered to be qualified for any for any recruitment process, on the date when he submits his application for consideration and participating in the recruitment process, stop. If the candidate did not possess the relevant qualifications, and if the rules or the advertisement, etc., did not permit relaxation otherwise, the said candidate will not be eligible for participating in the recruitment process and consequential enrollment if selected. Stop. From the facts of the case, it is clear that on the date when the recruitment process was initiated and the petitioner was enrolled in service, he did not possess the requisite qualification, which is a certificate of high school leaving examination for the concerned period, although he had appeared in the examination and the results were not declared. Stop. It is also not in dispute that subsequently the petitioner was considered successful in the said high school leaving certificate examination, and he obtained the relevant certificates and mark sheets, which, however, he failed to produce before the responding authorities. So, had it not been for the verification process, this fact perhaps would have never been discovered. The petitioner is a member of discipline forces, and the rules and provisions of the forces are very clear that any misinformation or wrong information or forged document will entail dismissal from service. Misinformation, wrong information, forged document submitted at the time of recruitment or at the time of his enrollment, if discovered subsequently by the authorities, will entail dismissal from service, with or without further punishments. But in the facts of the case, this court is of the view that where there is a clear admission by the petitioner that he had submitted false/forged documents, and the authorities were called upon to take an action in terms of the provisions of the rules and the act, such action cannot be faulted with. Therefore, on the facts of the case, this court does not find any infirmity with the impugned order dated so and so issued by the respondent authorities. The judgments pressed into service, although examines the scope of leniency in such cases, were rendered on facts which are different from the facts. So in Trilok Singh Rawat, the question of bigamy was examined by the court, and the case attempted to be projected by the attempt projected on behalf of the appellant was that there was a valid divorce prior to the second marriage, and this divorce was granted by the panchayat. Stop. The division bench refused to accept this contention, as no panchayat was authorized under any statute to grant divorce, and therefore the allegation of bigamy against the petition, against the appellant therein, was upheld. Stop. In Pranab Kumar Nath. It was another case where the allegation against the respondent was that of
Again,
contracting a second marriage during the subsistence of the first marriage and the dismissal of the petitioner from service to the charges proved. Stop. The petitioner in the respondent in the same appeal had rendered services enabling him to be eligible for payment of pension, and on the consideration that not only the wives but the children born out of the marriages will also suffer penury if the respondent was dismissed from service. And under such circumstances, the division bench altered the punishment to that of
paragraph 11, Lordship.
uh,
Paragraph 11.
compulsory retirement.
Not compulsory, other Lordship, without condoning the said misconduct. That misconduct was not condoned.
The matter was remanded back to the authorities to impose some other punishment
Lordship.
without condoning the misconduct. Stop. In the present case, however, the petitioner, it is admitted that the petitioner has rendered 9 years, 11 months, 11 days of service. And therefore, it did not make him eligible for pension. So the apprehension expressed before this court by the petitioner is that besides the petitioner losing his employment under the Assam Rifles, by virtue, in view of the order of dismissal passed by the authorities, the said order would render him ineligible for any further employment besides the defense sector. He will also be ineligible for employment in the civilian sector. Stop. This apprehension by the petitioner appears to be well-founded, as in view of the impugned order is an order which merely upholds the misconduct and dismisses the petitioner from the services, but there was no criminal proceeding initiated and the petitioner did not suffer civil imprisonment, etc. Under such circumstances, while rejecting the contention of the petitioner for altering the punishment or interfering with the impugned order dated so and so, this court, however, holds that the dismissal of the petitioner by the impugned order shall not be treated to be a bar for considering the petitioner for a fresh employment in the civilian sector under any authority or any public sector undertaking. The impugned order, therefore, shall be understood to have been altered to the extent indicated in this order. In the writ petition. Writ petition accordingly stands disposed.
Obliged. See, the matriculation certificate is the 2008. I have mentioned it.
2008, not 6.
Not 6. Obliged.
At your court,
Item 4.
Yes, Your Lord.
Ah,
My lord, in this matter, only the question is to be decided by this honorable court is that whether the deputy commissioner has empowered with any power empowered by the Lordship Registration Act, Lordship, to cancel any registered sale deed, Lordship. Lordship, in this regard, the Honorable Court of Honorable Court on 10/6/2025 directed the Deputy Commissioner come the district register to file an affidavit under what provision of law he has cancelled the Lordship sale deed, registered sale deed.
yes. Anything?
And
Have you filed the affidavit?
yes, they have filed their affidavit, and in the affidavit also what the stand they have taken in the Lordship impugn order, Lordship same affidavit has been filed. Your Lordship will find at page number 131.
Hmm. Yes.
And the Honorable Supreme Court in the, your Lordship,
What is there in the affidavit?
your
first?
Lordship will find at page number 131,
Ah,
paragraph 4, Lordship.
hmm.
That the deponent begs to state that after reviewing the documents submitted by the petitioner along with the statutory provisions governing the matter, it has been observed that the sale deed in question fails to comply with the essential legal requirements. Section 32 of the Guwahati Municipal Development Authority Act 1985 explicitly stipulates that no deed transferring land within the Guwahati metropolitan area may be registered without a no objection certificate from GMD approving the transaction. In
Okay,
this
first,
case,
let us see where is the impugned order.
your Lordship will find at page number 124.
124.
May I read, Lordship? The last part of the 124 of the order, Lordship. Your Lordship will find. Lordship, the Deputy Commissioner, in fact, he read, Lordship, Lordship, the amendment which has been made after, Lordship, 6th of December 2024. Whereas this amendment is not applicable in the case of the petitioner. In fact, if there is any provision also that conferred the power to the Deputy Commissioner. May I read, Lordship?
Hmm.
Last paragraph. Additionally, as per section 21A of the Registration Assam Amendment Act 2021, no testamentary instrument concerning immovable property except for house, flat, residential apartments, commercial building, or any construction or structure erected on a plot of land shall be accepted for registration unless it is accompanied by an NOC from the Deputy Commissioner. The standard operating procedure by the Government of Assam Revenue and Disaster Management Department by order number so and so dated 6/12/2022. 6/12/2022 issued under section 21A clarifies that a sale deed of land requires an occupancy certificate or prior approval from the DC, neither of which have been provided in this case. The absence of this statutory clearance leads to a further legal infirmity, reinforcing the sale deed non-compliance with the law.
Is it a sale deed or an agreement to sell?
No, Lordship, it is a final sale deed.
Sale deed.
Sale deed, yes, Your Lordship. The inquiry has found that the imputation of the said land was carried out in the name of Sri Rakesh Vaishya on 10/11/2022 solely based on the sale deed number so and so that
Can it be cancelled by the DC?
My lord, certain backgrounds are there. Lordship will decide on that part, my lord. But certain things are there. I should apprise your lordship.
No. Whatever it may be
My lord.
forged, it may be unauthorized, anything.
My
But once a sale deed is registered, can the DC say that it is?
Facts and circumstances.
DC may say that, DC may give an observation that this is unauthorized, it doesn't appear to be genuine, this, that, whatever, but can it be cancelled?
That observation is only there in respect of sale deed.
Huh.
And in fact, cancel the mutation order.
declared.
No, mutation order is cancelled on the ground that the sale deed has been held to be
Yes,
unsustainable.
that is why, my lord.
So firstly, the sale deed has to be held to
Yes,
be
that
incorrect.
part, that is to be, my lord,
So
decided by
long,
this.
rightly, wrongly, if there's a
My
sale
lord.
deed is there, how can you cancel the mutation? Somebody
it
has
is-
to, the
it is
active
a-
party will have to file a suit for cancellation.
Yes, my lord. That in that respect, that is why, my lord,
Hmm.
my respectful submission, your lordship will see, this is an interesting case where in our society does not happen, my lord, normally. With a view to deprive his own brother, my lord, the entire process has been done and without making party to the, my lord, concerned, my lord, person, my lord.
You mean
he
to
has
say
approached-
between brothers, there are no fights?
My lord,
There is
my
no
lord, this
fights?
type of brother normally, we did not face. my
You
lord.
you must not lose sight of Ramayana and Mahabharata. They're all brothers.
That's a bigger issue, my lord. Right, Joe. Kingdom, that is kingdom.
Cain and Abel.
My, that is there.
No.
So it is interesting, may I point out all these things? my lord?
Fights are always between brothers.
Yes, that is there, but my lord, to deprive the own brothers, my lord.
Anyway, but question is whether the
That
DC
part is there, my lord. I understand, my lord. That is there.
So if that is there, then subsequent consequential actions will also be bad.
Yes, but the party affected
Hmm.
will have no knowledge in case this case is decided in their absence, my lord.
They are not parties.
Not parties, my lord.
Lordship, in fact, your lordship.
That is why, that is the important.
Your lordship
Otherwise,
will
my lord,
find
state will not
Lordship, that
suffer.
Impugn order has been passed by the deputy commissioner at his own instance, lordship. There was no application. It is in fact reflected in the lordship impugn order itself.
Now, the affected party, the mutation was carried out in the name of the petitioner
Yes,
on the basis of the sale deed.
my
Earlier, whose name was there?
mother's name.
Seller was there.
There are two
He
sons,
was
my
also
lord.
lordship petitioner in this
And
case.
lordship, interesting, my lord. What they have there, my lord, they are hiding, my lord. Lordship will, it's interesting. That is why I have said, my lord. That part, so far law part is concerned, lordship will certainly see all aspects of the matter. Lordship kindly see first, my lord, annexure 1, page 28.
No, but how does the DC come to know?
Yes,
That
that
is another
application,
brother.
the objection has been filed, none other than the
This is not the
daughter of the brother of the petitioner, second petitioner number 2.
What has happened to the petitioner?
My lord,
What has happened to the brother? Is he not alive?
I think not. He can say well, my lord, in that.
Is he alive?
Lordship, there was no dispute between the brothers, lordship.
We are asking you a question.
Lordship,
You can answer
no,
yes or
Lordship,
no. Is your brother alive or
Brother is not alive, lordship.
not alive? Yes.
Not alive. And the,
That is
so
the
far
thing to be
property is concerned.
Even
he
if,
is-
even if, my
he
lord,
is
today
staying
matter
at
is
the
decided, my
What we
lord,
do is we remand the
can-
matter back to the authorities.
my lord.
The authorities will issue notice to all the affected parties.
Yes,
In
my
the mutation case.
My lord.
And will pass appropriate
Yes,
orders
that
according-
will be better, my lord. Even authority, he has not said the correct state of affairs, my
No,
lord.
lordship, only
Because-
humble submission before this honorable court is that, lordship. Since
Otherwise, that
uh,
will be injustice to the person.
Why have you not added them as parties?
lordship, your lordship will find the impugn order. Whether
First time, my lord,
whether
for,
order has
yes,
been
I
passed
make
to the
submission.
basis of any application that has been made by any person. Your lordship will find the impugn order.
No, then how has it filed? How has he passed the order?
It is own, that
Well,
How is he-
paragraph-
how is he
paragraph
doing?
8 to the
Is he-
repetition, lordship.
is he a person with divine powers that he comes to
Lordship,
know what is going on?
This is the affidavit of the deputy commissioner, lordship. He has filed the affidavit, lordship.
What is the, why you not put to notice?
Lordship, no, since there was no
Before
aggrieved person, lordship.
cancellation, where you put to notice?
Lordship, if there is any aggrieved person, he or she can approach the civil court, not the
Where the-
deputy commissioner. The
Where
deputy
you,
commissioner
where
is the
you put to
person.
notice before the impugned order was passed?
I have not been noticed, lordship.
Very well. So
But-
we remand this matter back. DC will issue notice to all the aggrieved parties and thereafter pass an order.
Lordship, then this
This
matter
order
can-
will remain,
Lordship,
will not be given effect to
Yes.
until the DC rehears the matter by issuing notices to all the affected parties.
That
And any order that is passed
Yes.
will
Only- yeah,
override this order.
That is correct. Only my humble submission before this honorable court is that
Hmm.
since there is no provision that has been introduced by the legislature under the Registration Act,
Hmm.
and the Honorable Supreme Court in a
You
landmark
go and
judgment,
argue all this before the DC.
only my humble submission. Lordship.
Why humble submission?
Lordship, I have
Your
stated
submission
everything.
has to be
I have-
in sync with the
Yes,
present
Lordship,
state.
I have everything stated. Your Lordship
we
will
have-
find.
We have heard you.
Lordship, no, Lordship,
No, no.
only this.
This order, your lordship may kindly see.
Lordship,
We are
Review
remanding
order.
it back. We are not,
Yes.
we are not dismissing
Your
it.
lordship may kindly see the review order. I have filed the review.
Yeah.
Your lordship may kindly find the review order.
Yes, where is the review order?
Review order, your lordship will find, review application, review order, 116, lordship. 116. Your lordship may kindly see. I have filed the review order. And all the judgment I have placed, he has not regarded this judgment of the Honorable Supreme Court. He has not even issued notice to any party because there was no any person who agreed.
He has given the reasons here.
He-
You are not challenging this review order.
No, both this order I have challenged.
Notice also he has annexed, my lord. Not that, my lord,
No,
authority
this is
did not
the
issue
notice,
this.
lordship,
And
notice-
paragraph 8 to the
notice-
writ petition,
notice
lordship will
is
kindly
not
have it.
regarding only regarding the objection, online objection, lordship. This
That
is not the notice.
process. Paragraph 8, he himself has stated.
Review, your lordship may kindly see.
In the sale deed, before you execute a sale deed,
Yes, your lordship.
it is necessary, is it necessary to obtain a no objection certificate from the
Lordship-
GMDA?
Yes, absolutely.
No, not
Mandatory.
necessary, lordship.
Sunday.
At that time, not
It is
necessary,
not correct,
lordship.
my lord. Not necessary is not correct.
When was the sale deed executed?
Your lordship will find 16/9/2022. 2022.
Hmm.
85 Act says, my lord. It is mandatory.
Let us see, GMDA.
Let me complete my submission, lordship. 16/9/2022.
নতুন ফোন দিয়ক।
এখান থেকে হয় 32 clause 32.
এখন আছে ৰুমত।
রেজিস্ট্রেশন এখন এবার দেখুন।
Clause
32.
32.
32.
It was required, lordship, before the amendment.
When was this provision brought in?
Lordship,
85.
on 15/12/2000.
Now that provision is, my lord, 1985 Act, my lord. This is.
It's there.
Yes, lordship. But lordship, thereafter, the legislature has amended the Registration Amendment Act 2021. And as per the act, lordship, your lordship will find at lordship section 21A of the Registration Amendment Act. Registration.
But this provision has not been touched. my lord.
Registration Assam Amendment Act 2021. এখন দেখা যাবে।
See, earlier there used to be a concept that whenever lawyers used to argue, they used to give a list of books so that it is easy for the court to procure all the books necessary
Yes, I'm.
instead of trying to hunt for the books and judgments in the middle of the hearing. If you are interested in hearing, furnish your list. Why do you want to take it out of your pocket at the time of hearing? Is it a magic wand which is available only to you? No, these are judgments by courts. Yes.
Section 21A of the registration sum amendment Act.
21
A,
A. Where is 21A? It's not
back
here.
side of the
Page
21.
28, I think.
Huh?
Page 28. No, this is state amendment.
State amendment.
Yes, Your Lordship.
20A.
1A.
No registration. No object, no reasoning, anything.
These are not required till 6 December 2022.
What is your case?
My case is, the Lordship, that the since the sale deed has been registered,
There was a plot of land
yes, Your Lordship,
owned by your mother.
owned by my brother, standing
Mother or brother?
mother.
Mother. You are two brothers.
Yes, Your Lordship.
So your mother has given the land or a part of the land to your brother.
The not my brother.
Uh,
It has
to
been
you.
given to me,
To you.
and my mother is living with me,
Uh,
and I have been taking
the
care of
entire
her.
land.
Lordship, there are several plots of land that has been occupied, and in the name of my father and also in the name of my mother, Lordship.
Hmm.
And only particular this plot of land, my mother has purchased the plot of land earlier, and that land has been transferred thereafter, Lordship. I initially,
This
Lordship.
land belongs only to your mother.
Yes, Your Lordship.
She has
She has purchased the land. I have
purchased the land. She
Yes.
has donated it to you.
Lordship, it has been executed, Lordship, as a sale deed, Lordship. We have applied for the, Lordship.
You are not clear.
Yes.
Your mother is the owner by virtue of purchasing a land.
Yes, Your Lordship.
Only your mother.
Yes, Your
It's not by inheritance from your father.
Yes, Your Lordship.
So this plot of land, your mother sold it to you.
Yes, yes, I
Sold it to you
Lordship,
by executing a sale deed.
sale deed, Lordship.
This plot of land is an independent plot of land, or is it
Independent
pertinent to
plot
the
of
other
land.
plot of lands?
Independent plot of land, Your Lordship will
Hmm.
find at page number 28 of my writ petition, Lordship.
Hmm.
Page number 28. I have purchased this land. If, Lordship, anybody has any grievance, Lordship, on the execution of the
You
state deed,
purchase only the land or the building?
Lordship, at the time of, Lordship, I have, Lordship, in the present sale deed, Lordship, I have,
Yes.
in the present sale deed, Lordship, my mother has transferred the entire property with land, Lordship.
Where is the sale deed?
Sale deed, Your Lordship will find at page number 66. Page number 66.
Now you come back to the amendment, 21 capital A.
Yes, Your Lordship.
Please read it again. You don't have a copy?
Your Lordship, I have put it here.
It নাই পোৱা নেকি? Right, so. আছেতো? নাই? কিয় নাথাকিব?
আছে?
কি লাগে?
ভালকে দিয়কচোন। Page number 28 ত চাওক।
Registration Act লাগে?
Hmm.
Yes,
One
yes,
Your
I-
Lordship will find no registration of non-testamentary instruments without any objection, no objection certificate Notwithstanding anything contained in any other provision of this act, no non-testamentary instrument relating to immovable property shall be accepted for registration unless the Deputy Commissioner of the concerned district issue a no objection certificate containing the description of
Such immovable property.
such immovable property to be transferred. It will not happen.
Huh?
This is not no objection. If this is
Then
This is the amendment.
this is the one you showed us.
Yes, this is the amendment.
which will happen. It will happen.
This is what you showed us.
But it is
Right.
little bit different, Lordship. It has been again amended, Lordship, on 6th of December two thousand
Where is it?
twenty.
Where is it?
Except what it was. Yeah, Lordship will find it is here, Lordship.
Hmm.
In my book, Lordship, it is here. No registration of non-testamentary instruments without no objection certificate. Notwithstanding anything contained in any other provision of this act, no non-testamentary instruments relating to immovable property except for house, flat, residential apartment, commercial building, or any construction or structure erected on a part of land. That is their logic. Shall be accepted for registration unless the Deputy Commissioner of the concerned district issue a no objection certificate containing the description of such immovable property to be transferred, and also such other no objection certificate which are required to be issued by the Deputy Commissioner or any other authority under any law for the time being in force or under any executive instruction, order, etc. issued by the state government from time to time. Except, Lordship, the rule says, Lordship, that except for house, flat, residential apartment, commercial building, or any construction or structure erected on a part of the land, Lordship. If it is there, Lordship, in such a situation, Lordship, no permission from the Deputy Commissioner is not required.
No,
And
here is a case where you are buying not only the land, you are buying the land with the building.
Yes.
Now your NO, if you go by the 21A,
yes,
NOC for that building, if it is only for the building you are
Yes,
buying, if it is only the building,
no, Lordship, this
you
is
come
the,
back to your agreement.
Lordship, this is the, I have applied for the NOC. Initially,
NOC of what?
for sale permission, Lordship.
Of what?
Flat, land and building, Lordship.
Then
Thereafter, this amendment has been come and the Deputy Commissioner has decided,
prior to that, what was the position?
Pro-
What is there in the GMDA Act?
Lordship, prior to that, Lordship, GMDA Act and the permission was enforceable. It was required.
Required.
After the amendment,
Hmm.
when the legislature has decided
Hmm.
that it can be dropped from the provision.
What is draw?
Lordship, the legislature has decided, Lordship, that if there is any house or building that is
No,
erected on the,
that is, according to me, an incorrect interpretation.
Yes.
If you are buying a house
Yes.
or a flat, then the NOC
No,
is not
Lordship, in
required.
case of flat, it is different, Lordship.
Whatever is there,
Yes.
there is an exception there. Building, apartment, whatever is there in the exception.
Yes.
In leaving out that exception, if there is any sale, then you have to get a NOC.
Lordship, it can,
Yeah.
Lordship, the thing is that Deputy Commissioner cannot issue
Either-
because the power has been seized. Your Lordship will find in the
you read
review
that-
order.
No, you read that 21A again. What is the effect of the exception?
Effect is, Lordship, that earlier, if any land or building is to be sold by the owner, in that case, Lordship, the permission from the Deputy Commissioner, it was essential in terms of the section 21A of the previous amendment,
Right.
Lordship.
Now, after amendment. what is
After the
position?
amendment,
Hmm.
Lordship, the legislature has decided that if any building has been erected and that building is not disputed,
Hmm.
and in that case, any house is constructed and the house is required to be sold along with the land.
No, no. That is not what it says.
It is there, Lordship.
No, no, no.
Over a plot of, it is there, Lordship.
No, no, no. You read your sale agreement. You are not transferring the building on a plot of land. You are selling the land with a building. There is a difference.
Lordship, the proposition is that immovable property, the right of the deputy commissioner or the district administration that has been empowered to issue no objection
You
certificate
show us
only in the
no,
case
you
of land.
Show us any authority.
Lordship,
You show us any authority that whenever there is a sale of a immovable property of land with a building, no NOC is required.
that is there, Lordship.
No.
It is on in the.
That is
Your
the-
Lordship will find in the
that is
review.
not a correct interpretation.
Your Lordship will find in the review also, Lordship.
Let
This
us
is
see the
in
review
review order also. It is stated by the deputy commissioner.
What is there in the review order?
Yes, para 3. Now, para 2, the operative law of when the sale deed was signed, section 21A of the Registration Act Act 1908 prior to its subsequent amendment was that no non-testamentary instrument relating to immovable property except for house, flat, residential apartment, commercial building or
No,
any
that
construction.
is what we are trying to tell you. If you want to, let us say hypothetically, you want to buy a apartment sold by Mr. Goswami. Mr. Borwa, you want to buy an apartment
Yes.
sold by Mr. Goswami. That apartment, needless to say, has to be built on some plot of land. Yes. It may be 1 kotha, 2 kotha, 3 kotha, 4 kotha, 1 bigha, whatever it may be. So when you make an agreement to buy an apartment, is it only the apartment you are buying? We listen to the court.
Yes, yes.
Is it only the apartment you are buying or the proportionate share of land?
No, Lordship, this is not the case to buy. It is not the case of a real estate, Lordship. It is the case of a
We
personal
know
user.
that. We are asking you
Yes,
so that it helps us to interpret.
yes, your Lordship.
You are giving an interpretation
Yes,
which according to us does not appear to be correct. You are not buying an apartment to say
yes, sir.
that this apartment is obviously built on a plot of land and therefore proportionate share of the land you will also become the owner. Therefore, you are buying land. No, you are buying the apartment. Can you let us alternatively ask you a question?
Yes.
Can you go to Mr. Goswami and tell him that, see, you will sell the apartments and the owners of the apartment will also become owners of the proportionate share of land. But I want to buy only that proportionate share of land. I don't need your apartment. Can you make an agreement to that effect? No,
Lordship,
on the ground that why you are not selling me the land? I don't need your apartment. Once I buy the apartment, I also become the owner of the proportionate share.
Lordship,
But
the-
I don't want this, I don't want to sell the apartment or I don't want to buy the apartment. I want only the transaction with the land. Vis-a-vis a case like this, where you are buying the land, which also contains a building.
now my humble submission before this honorable court is that so far the sale permission is concerned and the power entrusted to the deputy commissioner by under the provision of law, Lordship, in that occasion, Lordship, the honorable legislature has brought a specific provision and under the to registration of any properties.
This is
within-
also, even if you want to say that the DC in the review order says that 21A has taken away his power,
Yes, he says.
but he refers to 32.
Lordship, the difficulty was there, Lordship, that the deputy commissioner has subsequently relied the amendment that was brought after 6 December 2022. And after 6 December 2022, it is again required. That is the law, Lordship.
No. If you go by in the review order,
Yes.
para 22, second paragraph,
Yes,
he says 21, no doubt, has
Ah.
taken away the power,
Indicated, yes, Your Lordship.
right?
Yes,
However, 32 of the GMDA mandates.
yes. Your Lordship will find whether the deputy, without the permission of the Deputy Commissioner, GMDA has issued any sale permission, permission during that period or NOC during that period. Your Lordship will find at page number, that is RTI reply, Your Lordship will find at page number 128.
One 128.
Yes. During the period from February 2022 to 6 December 2022, regarding GMDA had issued sale permission NOC without sale permission from the DC office. It was found that no such communication was traced during the mentioned period. In that period, the GMDA has not empowered Lordship by the rule. There is no specific rule that has been empowered the Lordship.
That interpretation does not fall from page 128. You are asking a question, they are giving a reply. They are
But
not
you-
saying, they are not saying that it is not issued or issued. They are saying there is no information.
Yes, Lordship, because they do not have, they do not have,
That
did not
interpretation is-
issue any NOC. And so far the section 32 is concerned, Your Lordship will find this provision neither specifically authorize any person or nor any specific mention that has been made in the law to empowering the any authority without the Deputy Commissioner's permission to issue any NOC for sale, final
Now,
execution of
the,
sale.
why the Deputy Commissioner raised the objection, Mr. Goswami, on what basis?
Yes, that I am, my lord. I'd like to clarify certain issues. Lordship will kindly find Annexure 3, page 36, my lord.
36.
Right. That will clear the picture, my lord. Which my learned friend, my lord, has not pointed out. This is the affidavit on the
Right,
part of
yes,
the
affidavit.
petitioner number 1, the mother of the petitioner number 2. I so-and-so, aged about so-and-so, 63 years, wife of so-and-so, so-and-so, so-and-so. That paragraph 2, my lord. I am the absolute owner and possessor of a plot of land measuring 3 kathas, so-and-so, covered by dag number, so-and-so, Capimanar, so-and-so, Beltola, so-and-so, so-and-so. That Sri Rana Kumar Boisho and Rakesh Boisho are my sons. That my younger son Rakesh Boisho intends to construct a residential building over 1 katha 10 lesa western part out of my aforesaid 3 kathas of land. That I have no objection if my son Rakesh Boisho construct a residential building on 1 katha 10 lesa western side over the said plot of land which is under my absolute ownership and possession, and further I have no objection in taking loan from so-and-so, so-and-so. My lord, based on this is the, my lord, NOC in fact, my lord, and based on which, my lord, the GMDA permitted to construct a building. Thereafter, no communication on the part of the petitioner seeking, my lord, any no objection certificate from any authority.
Seeking? Yes,
Only one thing, my lord, for gift, one thing is there only, my lord,
I have applied for sale permission.
for gift. That is also all right.
One purpose.
Yes.
No, he claims to have sold the land. Now, what
Yes,
is-
the
what is-
next time, my lord,
What is this affidavit, Mr. Borua? This page number
It was
36?
means some part of land, it was Lordship.
that is the thing, my
Sometimes
lord.
it happens, Lordship, that in the entire plot of land, there is specific site that has to be mentioned when Lordship the.
Why was this affidavit necessary in the face of a sale deed?
No,
if
it
you have
is not-
purchased-
It is not necessary. I have not enclosed in the sale deed, Lordship. It is not the part of sale deed, Lordship.
No, where was this document submitted?
In the
For the
year
purpose of
2012,
obtaining permission for
Permission.
construction of, my lord, building
No,
Then?
Lordship.
on a part of land.
It was in the year 2012, your Lordship will find.
Yes.
Hmm.
2012, Lordship. Only the issue is that, Lordship,
And
here
there-
only issue is that whether Deputy Commissioner has exercised the power that has been conferred under any provision of the law that has been enacted by the legislature as Registration Act, Lordship. And so far the Lordship, Satyapal Anand case, this ruling, Honorable Supreme Court has specifically mentioned that, Lordship, in fact, the Registrar General of the Registrar General has also no
No,
authority, Lordship.
after this affidavit at page 36,
Yes, Lordship.
this was submitted by your mother,
Yes,
perhaps by you.
yes.
This 36,
36, it was in the year 2012, Lordship, when the process has been made for, and this sale deed has been executed now, Lordship.
no, this 36
Yes, your Lordship.
has relevance to what effect?
Lordship,
Why was this affidavit necessary? For what
Lordship,
purpose?
when GMDA has instructed, Lordship, that and for the architect part of the building, Lordship,
Hmm.
then there is specific needs of the Lordship demarcation of the land, Lordship, because the east, west, and
At
everything.
that point in time, you did not want to buy the land.
At that time, Lordship, my mother has not sold the land to me, Lordship. Now, in the year 2022, Lordship, she has executed the sale deed, Lordship, in terms of the Registration Act. And she has applied for the
Now-
sale permission, Lordship,
No,
and
that's-
only on the basis of
At the age of
Section
79,
51A
80 of his
the-
mother.
It is irrespective. Now only the core question is to be decided, Lordship, that whether Deputy Commissioner has been empowered under any provision of law of the Registration Act, Lordship, in contrary to the provision of the Supreme Court that has been passed in the case of Satyapal Anand versus State of MP and others, Lordship,
Mm.
that the Deputy Commissioner
You
can.
do one thing, you give us a list of what documents, what rules, what sections you want. Because in the course of the hearing, it is difficult to hunt for these materials and then study.
I have in the last occasion, I have already placed, Lordship, the judgment of the Honorable Supreme Court, Lordship.
Chaniki,
He has also
Not
manipulated
there.
this
Can you
affidavit
submit
also.
another list?
Yes, Lordship. I have not submitted any list, Lordship.
Uh,
Can it be fixed on tomorrow, Lordship? I can submit.
Not tomorrow. You submit this today to the court master. All the judgments, all the rules, all the regulations, amendments, whatever you want. You don't have to give copies of that. You just give the reference in the list. We'll take it out. A judgment, give the citation. If you think you can give the paragraph numbers. A particular amendment, just give the amendment.
Yes, sir, Lordship.
If you have the gazette number, date, we'll take out the copies. So that it is easier to correlate.
Yes.
What
it
you are
is-
relying on
it is
and
true,
for
Lordship.
what purpose?
It is true, Lordship. Lordship, only, I will submit, Lordship.
We'll
only-
continue
I-
after that. You give us the materials. We'll take up the matter again on 17th,
Yes.
17th February. You give us the materials.
In the
Well,
meantime,
can it be taken up on 19, my lord? 19 in Thursday, my lord.
All right, 19.
9. Oblige.
Give us before that.
Lordship, 19, I have some difficulties, Lordship. I have. This fixed, Lordship.
Let us have it on 12th.
Yes, yeah, Lordship.
Nice one.
Yes.
12. Huh?
Mr. Kotogi, you are appearing in the matter.
No, no.
No, is it? We can have it on 12th if you want.
Okay,
Yes.
no problem.
12th, but give us the information.
12, give-
I will submit, Lordship. But tomorrow, Lordship, today.
Tomorrow you do it. Mr. Goswami also, you may submit the information.
Right.
The parties submit that the pleadings are exchanged, matter is listed for, ready for hearing. An attempt was made to hear the matter, but the counsel for the petitioner has referred to judgments in support of his contention, as also amendments carried out to various statutes. Therefore, in order that proper hearing can be taken up at an early date, we permit both parties to furnish a list of case laws which they propose to rely on, as also the relevant statutes and their amendments, if any, to the court master. As agreed to, let the matter be listed again on 12th
Yes,
Well,
of February.
highly obliged.
Wait a minute. Well, so far, item number 8 and 9 is concerned, are concerned, my lord. Some provision of 64 Act are under challenge before the division bench, my lord.
What act?
1960, that Requisition and Acquisition Act, my lord. This is also some amount of connection is there in this. in
Let it
both the
come on
cases.
after 3 weeks, my lord.
8 and 9.
8 and 9, my lord.
Okay. Item 8 and 9, it is submitted at the bar that these matters pertain. What are you challenging here?
Here in proceeding drawn up under Assam Land Requisition and Acquisition Act 1964. my lord.
The proceedings initiated under the Assam requisition,
Requisition and Acquisition.
requisition and
Is
acquisition
the Act 1964.
Act 1964. Stop. The learned counsel appearing for the parties submit that a similar issue is pending disposal before a division bench. Division bench.
He said division.
Yes, this is some provisions of the act are
Some
challenged.
provisions of the Act of 1964 are assailed in a proceeding before the division bench, and therefore
I don't know how it would.
the parties submit that the matter be listed again after 4 weeks
What?
to enable the parties to apprise the court as to the status of the proceedings before the division bench.
My lord.
4 weeks after 4
Yes.
weeks.
Obliged.
Yes.
Malab, I'm only relying on that judgment, Malab. Last time I have already given Malab.
Swadesh.
Malab.
Swadesh Kumar.
Yes, Malab. 2020, 10 SCC, 235, Malab.
2022.
Malab.
No, for what purpose you are relying on?
Relying, Malab. It is Malab regarding the so 14, 13, 14, Malab. The mandate of the Malab, termination of the mandate of the arbitrator. Malab. Already the arbitrator has been appointed, Malab. Now he said that since there are 3 arbitrators, one has been transferred out and we wanted to substitute him, Malab. He is saying that now after coming of the new provision, you cannot substitute. So, Malab, that means Malab and Malab, he have filed an 11-6 petition for appointment of arbitrator. But Malab, before that, Malab, for appointment of arbitrator, the earlier mandate of the arbitrator has to be terminated, Malab, because already 2 arbitrators are already there. So, Malab, for doing that, Malab, he has to approach the civil court, Malab, under section 2(1)(e).
Arbitration Act.
So, my lord, I would like to point out, my lord, para 32 of my lord, the day of the judgment, my lord. 1E of the answers. My lord, where it is ruled that, my lord, he has to file an application under section 21E of the 1996 Act, and such dispute cannot be decided on an application filed under section 11(6) of the 1996 Act.
You are reading from?
My lord, I am reading from the judgment, my lord, para 32(5), my lord.
गरम क्यों किया? खाने के लिए दे दो।
My lord, I am reading para 32, my lord. Relying on, my lord, 32.5, my lord. Subpara 5, my lord. May I read, my lord?
Yeah, read it.
In case where there is a dispute of the controversy on the mandate of the arbitrator being terminated on the ground of mentioned in section 14(1)(a, such a dispute has to be raised before the court defined under section 21(e) of the 1996 Act, and such dispute cannot be decided on an application filed under section 11(6). My lord, they are not disputing the, my lord, they are not raising that ground, my lord, to, my lord, terminate the mandate of the arbitrator, my lord. But I am saying, my lord, since, my lord, the arbitration tribunal panel has been, my lord, a 3-member arbitrator was already appointed, my lord. So, and we are trying to substitute one of the arbitrator, my lord. So the arbitrators have already been appointed.
What about 29A?
29A, my lord, that has come, my lord. Exactly, my lord. I'll read it out, that also, my lord. 29A. Lordship might, it has come into effect, my lord, with effect on 23/10/2015, my lord. So, my lord, our arbitrators have been appointed in 2010 already.
Very well. Now, what is the 2010? Will it mean, does it exclude the arbitrations prior to 29A?
My lord, 29A itself
29A defines a time to be in effect from 2015.
Yes, my lord.
Does it mean, or does it say that all arbitrations which commenced prior to this amendment,
My lord.
this particular clause is not applicable?
My lord, it cannot be retrospective, my lord.
There is no retrospectivity. I'm not saying that your arbitration prior to 29A, you initiated an arbitration which lasted for 15 years.
My lord. Yes, my lord.
Then after 29A, you
My lord.
cannot come and say, no, by virtue of 29A, that arbitration cannot be treated to be valid because it has gone for 15 years. I'm not on those cases. But where your arbitration is still pending,
My lord.
conclusions or awards have not been arrived at by the tribunal,
My lord.
and 29A comes in.
My lord.
On a day when 29A comes in,
My lord.
your arbitration is still pending.
My lord.
Are you still saying
My lord.
that 29A is not applicable?
My lord, I am saying that.
On
my lord,
what basis?
my lord, on what basis, my lord? Kindly come to pay section 14, my lord.
So section 14 operates on a different.
No, my lord, that delay part is also included here, my lord. Kindly see, my lord. 14(2), my lord, if a controversy remaining concerning any of the ground referred to in clause A of subsection 1, a party may, unless otherwise agreed by the parties, apply to the court the receipt on the termination of the mandate. If the if under this agreement, subsection 3, section 30, an arbitrator withdraws from his office or part.
Mr. Counsel, you are saying that this 14, if the situation under 14 is there, then you have to apply to the court.
Yes, my lord.
Right?
My lord.
You see the subsequent judgments you have not seen. Later judgments.
My lord,
After 4.
my lord.
Sorry.
Yes, my lord.
After this interplay. You see all the judgments after that. The law now is a referral court is only to see the existence of an arbitration agreement. And if the parties have agreed to a procedure and the procedure has not been followed, then the referral court will refer the matter to an arbitration.
This is not
On-
referring to, but already it has been referred, my lord.
Referred.
You cannot come twice, my lord.
No, you cannot come twice.
Under 11.6, my lord.
Then we can certainly make this observation that in view of section 29A, the arbitration fails.
My lord, my humble submission, my lord, 14A applies, my lord, for it says, my lord, he becomes de jure or de facto unable to perform his function or for other reasons fail to act without undue delay.
That is for replacement.
My lord, the replacement. my lord.
Replacement of the, they are
Arbitration.
asking for that.
My lord.
They are
Well,
saying
he-
that, they're saying, firstly, there was a tribunal of 3 arbitrators.
My lord.
One got transferred out. You did not make immediately any attempt to replace him.
No, immediately, my lord, we have,
Well, you
but he said
immediately.
that now,
When-
after
when
coming
did
out
you-
this
when did
29A,
When
you
did you
cannot.
make that attempt to replace him? Which year, which date?
Well, after 15, my lord. Obviously.
After 15.
But
So after 15,
that is why he pointed out that after coming of 29A, you cannot. But my submission is that since, my lord, the Honorable
see,
Supreme Court also
after
said.
15,
Yes.
if you want to do, then you'll have to apply 12.5. After 15, if you want to replace him,
My lord.
then he has to give a consent.
My lord, but it is not applicable to arbitration which were already, my lord.
Read 12.5 and tell me it is not.
My lord, this is also come from, my lord, 2023.
Exactly. So read the section, read 12.5.
When a person is approached in
12.5.
connect, 12.5, my lord.
Yes.
I'm 12.5, notwithstanding anything, any prior agreement to the contrary, any person whose relationship with the parties or council or subject matter of the dispute fall under any of the categories specified in the schedule shall be ineligible to appoint as arbitrator, provided that parties may subsequent to dispute having arisen between them waive the applicability. But this sections, my lord, my humble submission is this section also applicable after, my lord, 2310 to 2015 only.
No, Mr. Counsel, we are not answering the core issue.
Now,
Once
yes, my lord.
once this amendment is carried out,
My lord.
unless the amendment is specific,
Exactly.
that it shall exclude
Yes.
all those
My lord.
which were carried out prior to the amendment.
My lord.
From the day the amendment is brought into the statute book,
My lord.
it is deemed to be applicable.
Excellent, my lord. Now,
And
for
more particularly in case of 12.5, read
Well-
12.5, it begins with notwithstanding.
my lord, for that, my lord, I am saying, my lord, that for that also, my lord, he has to approach the civil court.
No.
That for this purpose, they have been incapacitated.
No,
my
no,
lord.
no. Mr. Counsel, we permit you to argue, doesn't mean that you'll keep on arguing.
My lord, I will not.
Without
my
any
lord,
reference
That is my,
to-
my lord, that is the only submission I will make,
No,
my
you
lord.
can't make a submission contrary to law.
My lord,
As
no,
an
my-
officer of the court,
my lord,
you cannot.
my lord, thing is this, my lord, I
You
am,
cannot.
I am relying on
Please
failure.
withdraw your submissions.
Mm.
If you need time to go through the judgments, go through. Then make your submissions. You're making submissions contrary to law laid down by the apex court. which is
Mala, I
binding.
cannot make Mala, I'm sorry, Mala, if I haven't made Mala, I have no intention to make
therefore,
any submission
see,
contrary to Mala.
Please understand two
Mal-
things.
Mal-
This High Court is not only set up to hear your cases.
Mal-
So we cannot give you indefinite time to argue your cases. You have a definite time to argue your cases on the facts, read the law, place it before the court, attempt to persuade the court, accept your arguments. You can't keep on arguing a matter
No, Mala,
with
only this
without
point, Mala.
taking into consideration the law which has come into. You are going back to pre-1915, 2015.
But Mala, this judgment is Mala relevant on 2022, Mala. Lordship may kindly say.
This is on a different issue. This is on the issue of section 14.
Mala.
If you accept the is
Mala,
the question
sir,
of
29 Mala, 14 cannot come,
applicability
Mala.
of 12.5
Mala.
is the question of applicability of 12.5 vis-a-vis section 14 is also a question in the judgment. Has it been answered by the apex court?
But my lord, what I have gone through, my lord,
You show
one
us
para,
that-
my lord, one
that
para I would
in-
like
in
to rely, my
cases
lord.
in cases which are covered under 14,
Hmm.
their the effect of section 12(5) and 29A is excluded.
In the, here it is said, my lord, the application for appointment of arbitrator or arbitrator shall be maintainable. It is, my lord, 32(2), my lord, it says, in case where there is no written agreement between the parties on the procedure for appointment of.
Mr. Counsel, we'll close the hearing if you are not interested in answering the queries of the court.
My lord, I'll answer, my lord.
If you are interested in answering the queries, we'll hear you. If you want to go on arguing as per your parameters, we have heard you, we'll reserve and pass the orders.
Well, that is the only submission I
Very well.
wanted to make.
Heard orders to be dictated.
Some judgments are there, my lord.
We will have the matter listed on 26th of February for orders. Mr. Hussain, don't give us this bunch of papers. Give us a gist of the judgments on the points on which you are
Yes,
referring the judgments.
Now,
This is a case of, this is the case for appointment of an
Yes,
arbitrator.
yes, sir.
We
My
are not
case is
deciding
covered,
your
my lord.
dispute.
Yes, it is covered, my lord.
What is covered?
I will give the gist of this.
26th. List on 26th for orders. Mr. Hussain for petitioner, Mr. Goswami for the railways.
26.
26th for orders. Yes.
Here, my lord, they say it is settled law, my lord. They
Who's your opposite party?
he is there.
Yes.
Both the parties are, my lord, binding by the arbitration clause. Here, your lordship may kindly see the regarding this DRC. Arbitration clause is at page 55.
You want to say this is not a binding?
No,
This is the directory.
that is one of the submission.
Directory.
Another submission is that I invoke the DRC clause. They did not appoint the DRC as per the agreement, my lord. Here, your lordship may can. Now, nobody can rewrite the agreement, my lord. Unilaterally, alteration is not permissible, my lord. This is well settled law. In the contract, unilateral alteration is not permissible. Here, your lordship may kindly see page 112. First of all, my lord, this is page 102, my lord. I invoke the 102, then the position will be clear. Page 102, annexure 32. I invoke the DRC clause, my lord. Therefore, you
102.
could sir, my kindly refer the dispute to the dispute redressal committee. Now, what is their reply, my lord? Their reply is that they wanted to change the DRC, my lord, at page 108.
One zero?
108, my lord.
108.
Page 108, my lord. Then, my lord, I declined.
No, this is not a declination.
Yes.
This is the letter where
Yes.
where the response says that we have received your letter for requesting us to consider DRC, your lordship.
All right,
108.
we'll take it up in the second half. Come back in the second half. They require some more.
My lord, in this case, we have approached your lordship for appointment of arbitrator as the respondents failed to act as required under the agreement. And in this respect, lordship, the lordship may come to page number 55, arbitration clause is there.
Hmm.
And next page, Lordship, this is page number 56. Subclause 1. If the contractor consider any work demanded of him to be outside the requirement of the contract or dispute any drawing, record or decision given in writing by the engineer in charge, or if the engineer in charge consider any act or decision of the contractor or any matter in connection with arising or out of the contract or carrying out of the work to be unacceptable and is disputed, such party shall promptly within 15 days of arising the dispute request Chief Justice, Chief Engineer, CPM, CPM, or where there is no Chief Engineer, CPM, request the Additional Director General, a Special Director General who shall refer the dispute to Dispute Redressal Committee within 15 days. This is important, my lord. Now your lordship may kindly come to page 102. On 15/11, my lord, at page 102, on 15/11, 2022, we requested for referring the dispute to redressal committee. Now, next page, my lord, page 108. The respondent acknowledged the receipt of my letter on 30/11/2022. So from that day, they have to appoint the and refer the matter to the DRC. Now, next page, lordship may see 9/12/2022. Please find the letter attached. You are requested to kindly give necessary consent for changing the constitution of DRC, so that DRC may be constituted earlier. So they wanted to rewrite the contract agreement, which we refused on 15/11/2022. At page 110. Then your lordship may kindly come to page 112. 112. Despite our declination to accept the rewriting of the contract agreement, they constituted the DRC on 14/12/2022, consisting of, here your lordship, this is the important, chairman, chief engineer, member SE so-and-so, member SE Silchar. This is the contravention of the contract agreement, which is at page, lordship may kindly come to page 50. In the bottom, lordship may see the clause 25. The DRC will be constituted with chairman. Chairman, there is no dispute. Member SE, there is no dispute. Member third, SE Guwahati. Here they included, instead of SE Guwahati, SE Silchar. This is in contravention of the contract agreement. And it is not binding upon me. I am not bound to accept this. So we declined. Now 15-day time is over. So they failed to act within the time prescribed under the contract agreement.
No,
So-
under the contract, where are the members specified?
Here at page 50, my lord.
Page 150.
50.
50.
The part agreement is there.
50.
In the bottom, my lord, clause 25.
Hmm.
Chairman, lordship, chief engineer Shillong, member is there. Member SE Guwahati. And here
This was not subsequently amended.
no, and if any amendment, it is not binding upon me. Once the contract agreement is entered into, signed by both the parties, any unilateral alteration is not permissible. It is settled law, your lordship.
Hmm.
And particularly arbitration agreement, it is not permissible to rewrite either by the court or by the party unilaterally without the consent, like section 12(5).
So here they have failed to act. Now there is no impediment for appointment of arbitrator, despite they are resisting to appoint the arbitrator. Second chance, law does not permit to give them the second chance. Because in deep trading case, your lordship may see the after 30 days appointment was made, then the Honorable Supreme Court says it is invalid. And having no consequence. So my case is very clear, my lord. And otherwise also DRC is not mandatory. And DRC is constituted of their own member. This is also hit by section 12(5). How there, and this is termination of the contract. Your lordship may see how they can decide the termination of the contract, legality and validity, their own officer, own chief engineer, own superintendent engineer. They have terminated and they want to decide. Logically also, my lord, this is not permissible and not.
Yes.
Lordship.
Why are we being detained here? It's you have all agreed on arbitration. Ultimately, the dispute has not been resolved.
Exactly. But
Now at
Lordship-
this stage, even assuming we accept your contention that it needs to go to a dispute resolution,
Lordship.
unless you give us some indication that the dispute resolution committee has been constituted, ready, it is willing to
Yes, Lordship.
go
ready.
out and redress the disputes
Lordship.
effectively.
Lordship. Lordship, we
Why
have,
should we relegate it to the dispute resolution now, when you have already agreed upon arbitration in case of failure? We'll consider this to be disputes not been resolved due
so
to.
Lordship kindly 55, page 56, your Lordship.
Let us go back to your clauses again, 55. is it?
Yes, Lordship. Okay, page 55, clause 25.
55.
Uh,
Clause 25. Read again, please.
Yes, Lordship. Clause 20, except where otherwise provided in the contract, all question and disputes relating to the meaning of the specification, design, drawing, and instructions herein and before mentioned, and as to the quality of workmanships or material used on the work, or as to any other question, claim, right, matter, or thing whatsoever in any way arising out or relating to the contract, design, drawing, specification, estimate, instructions, order, or this condition, or otherwise concerning the work or the execution or failure to execute the same, whether arising during the progress of the work or after the cancellation, termination, completion of abandonment thereof, and the dealt with the mentioned hereinafter, subsection 1. If the contractor consider any work demanded of him to be outside the requirement of the contract, or disputes any drawing, record, or decision given in writing by the engineer in chief, or if the engineer in chief consider any act or decision of the contractor or on any matter in connection with or arising out of the contract or carrying out of the work to be unacceptable and is disputed, such party shall comply within 15 days, your lordship, of the arising of the dispute, requested the chief engineer / CPM, or where there is no chief engineer / CPM, request the additional director general / special director general, who shall refer the dispute to dispute resolution committee. First, he has to approach the your lordship, chief engineer. If not, then additional your lordship, general manager, your lordship. But he did not. Within 15
if it is a case
Yes,
that
Lordship.
immediately upon dispute he is come to the court filing 11(6). It's not a case like that. There has been communications
But
between the parties.
But there is also a specific.
Now, how does it prejudice you
That, yes, lordship.
unless you say that no, the disputes which are projected by the petitioner are no disputes at all, or there are these claims which he has made have substantially already been resolve whatever residual claims are there, can always be looked into DRC, therefore no need for arbitration. This is not your case.
Lordship.
You don't know as on date whether DRC will be able to resolve these claims.
There is a specific also time period, your lordship. If 60 days,
So
if
that
if-
has long gone.
no lordship.
When was the dispute? First, when was the demand made? When was the application for DRC made?
So lordship, he has to first exhaust the DRC.
He has given, but you have attempted to change the
No,
members
lordship,
of the
kindly,
DRC.
kindly, lordship, kindly. Lordship, this is the time prescribed for the 15 days.
Hmm.
Time has been started from the third. He has requested us to 15/11/22. Said letter has been received by us 30/11/22. Within 15 days, that means that the time started from the 30/11/22, and within 15th of December, before 15th of December, we have to consider DRC. So the 14th of 12, we have to consider DRC. And we ask him to, your lordship, place their grievance before the DRC.
No, your constitution of DRC is again contrary to the
Is it-
earlier communication.
This is lordship kindly.
Yes. Contrary to the agreement.
No, lordship. Whether we have failed to consider DRC or not, your lordship, we are not failed.
You have identified the members of the DRC.
Lordship, kindly,
Page number 50.
lordship, kindly page 114, your lordship. Annexure 38.
Hmm.
The last part, but may I read, your lordship? This is a letter written by your lordship, petitioner, your lordship.
Hmm.
And dear sir, he has reflected all the letters, communication letter, your lordship. Your letter number 1412, your letter number 912, all these things. Your lord. Dear sir, with reference to your aforesaid letter dated 14/12/22, whereby you have considered DRC comprising of 3 members of settlement of the dispute through DRC before going for arbitration. However, it has come to our notice that DRC considered by you is not in terms of the agreement dated 19/5/2022. This is the GCC, your lordship. Apart from that, your letter itself shows that you have not considered DRC in accordance with the terms of the agreement, rather on the basis of some circular dated 9/20. At that time, there's a circular. Actually, what happened that time, one person has carrying the dual charges. That because this 2 person has required, so 1 person, so that because we are coming, bring 1 person from other region,
But
that
how
other
do
zone
you-
also,
how do you-
Silchar.
How do you explain
Lordship,
page number 50?
Lordship, kindly, please, lordship. Hence, the dispute resolution committee constituted by you is violated the terms of the agreement and invalid and not binding upon us. Moreover, at the belated stage, you cannot unilaterally rewrite the terms of the agreement. Apart from the executive engineer, Guwahati has offered us to give our consent for change in the consent DRC, but we never got our consent. Hence, DRC is so constituted by you invalid and not binding upon us. Last line, your lordship. It is therefore we requested you to the good self to kindly recall your letter dated 14/12/22, your lordship. He again requested us to recalling the 14/12/22. That letter we have considered DRC. So lordship, we definitely recalling our earlier letter.
Constitution of DRC is contrary to the members which are described in page number 50. How you can't constitute with any member? Your agreement says these will be the members. Why did you specify the names? And then you constituted with some other member.
So immediately, so that part we have our admitted our guilt, your lordship. We have when he requested us to recall the earlier letter, we immediately recall our earlier member,
Then
and again install our earlier member, bring back the earlier member. Your
where is
lordship.
that
Next page, running page 5/11 5/1/2022.
page number?
Page number 116, your lordship. May I read, as the agency MSG.
This is after the 15 days.
No, lordship. We have already considered the DRC within 15 days, but he is not satisfied. We are
Can't
seeking.
constitute a DRC without any member. A DRC constituted will have to be understood to be a DRC with the members,
Lordship.
right? So you constituted somebody, one of the members was some other person who was not named. You wanted his consent, he refused to give consent, requested you to recall.
Yes,
And
lordship.
subsequently you reconstituted this with the
Yes, lordship. We are-
members, but this is on 5/1/23. When does 15 days expire?
15-12.
If you go by your mandate,
Lordship,
it is very clear that the mandate is that you'll have to attempt to resolve the dispute within 15 days.
Lordship,
If not, reconstitute or constitute an arbitral tribunal. That is what the agreement says.
Lordship.
So that has not been done. Now, this is a arbitration of
Sole arbitrator.
sole arbitrator.
No.
Yes,
Is below 20 crores.
yes, my lord.
All right, heard
Yes.
Mr. R. Hussain, learned counsel for the petitioner, Mr.
PK Medley.
P.K. Meli, if learned CGC,
Lordship.
appearing for the respondents. This is an application under Section 11 of the Arbitration and Conciliation Act. The petitioner was awarded a contract for construction of so-and-so, page number 35, subject of ligas. Pursuant to the said contract, an agreement was duly executed by and between the petitioner and the respondent. As per the said agreement, if any dispute arises between the parties, then as per clause 25, the procedure prescribed will be followed. So, in terms of clause 25, the party, the contractor, if he makes a claim of dispute, will request the respondent authorities to refer the matter for dispute resolution before the dispute resolution committee, which is to be constituted by the respondents in terms of the contract agreement. Stop. This reference is to be made within a period of 15 days from the date received, from the date on which the disputes raised by the petitioner are received. Stop. The reference is to be made along with a list of disputes with the amounts claimed. Stop. The dispute redressal committee. About resolution as the redressal committee. Dispute redressal committee shall give its decision within a period of 60 days, extendable by 30 days by consent of both the parties from the receipt of reference from the chief engineer / CPM / ADG / SDG. Stop. Thereafter, the DRC will submit its decision to the concerned ADG / SDG for acceptance. The ADG / SDG in a time limit of 30 days from the date of receipt of the DRC decision will convey acceptance or otherwise the decision. Stop. If the DRC fails to give its decision within the aforesaid period, or any party is dissatisfied with the decision of DRC, then either party may, within a period of 30 days from the receipt of the decision of the DRC or expiry of the aforesaid time limits, may give notice to the respondents for appointment of an arbitrator. Stop. Where the claims are below rupees 20 crores, then the matter shall be referred to a sole arbitrator. Stop. Para Mr. R. Hussain, learned counsel to the petitioner, submits that after the petitioner raised its claim of the claim of dispute. Yeah. Certificate, yeah, after the petitioner undertook execution, you completed or it was terminated?
Terminated, my lord. Though completion certificate was also issued, but
Then?
termination was also there
Then
subsequently, my lord.
you did not complete any part.
No, Lord, sir,
Some part may be there,
Lord,
disputed part
sir.
may be there.
According to the petitioner,
So many
he had
defects are still
completed the
there.
work. However, the same is not accepted by the respondents, who in turn submitted that because the petitioner could not complete the work, the contract was terminated. So be that as it may. The petitioner raised his grievances by the communication
15/11/22.
page.
Page
15/11.
102, Lordship. 102. Annex of 42.
Not 102, my lord, this one, at page 90.
By communication dated 5/10/2022, raised a final claim amounting to rupees 1,67,97,983.
No. Question. Question. Finance stop of the rest.
Thereafter, the respondents replied requiring the petitioner to attend the site for due measurement, joint for measurement in the joint presence of representatives of the petitioner and the respondent. Pursuant thereto, the petitioner by communication dated 15/11/2022 raised his final demands, again of the said amount, requiring the respondents to refer the dispute to the DRC. Stop. The respondents replied by communication 1/12/2022, intimating the petitioner that the communication for referring the dispute to DRC was received on 3/0/11/2022. And the DRC will be constituted accordingly. Stop. Subsequently, on 9/12, a committee was constituted comprising of members, one member who is at variance, one member which is at variance from the members prescribed in the contract in respect of the DRC. Stop. Therefore, consent was sought for from the petitioner. So the petitioner thereafter declined to give consent and requiring the respondent authorities to constitute the DRC as per the specifications of the contract agreement. Stop. Subsequently, on 5/1/2023, the respondents replied to the request made by the petitioner by reconstituting the DRC comprising of the members as specified in the contract agreement. Stop. Where according to the petitioner, the reply received on 5/1/2023 is beyond the period prescribed under clause 25 of the contract. Therefore, it was incumbent on the respondent authorities to refer the matter to arbitration for a sole arbitrator. However, that not having been done, the petitioner issued a notice dated 8/2/2023, calling upon the respondents to appoint the arbitrator. Have you named any arbitrator?
No, my lord, sole arbitrator is not required. For the
Sole-
three arbitrators.
Any arbitrator? Sole arbitrator, stop. What happened after that?
They
After-
did not appoint the arbitrator, my lord.
After, in response, the respondents stated that since the DRC was constituted, it was necessary to have the matter referred to the DRC in terms of the clause of the contract. And that not having been done, a question of appointing arbitrator did not arise. The matter remained that the matter was being situated thus, the petition has been filed, seeking a direction, seeking an appointment of an arbitrator under section 11. Mr. Mehdi submits that the prescription of clause 25 was required to be followed, and which was followed by the respondents. But in spite of that, petitioner did not yield to the steps taken by the respondents by constituting the DRC in terms of clause 25. Accordingly, since the procedure prescribed under clause 25 has not been followed, then this petition is premature at this stage to seek appointment of an arbitrator. Stop first. The prescription under Rule 25 for attempting to resolve the disputes through the DRC must be resorted to by both the parties as it is a part of the agreement executed by and between the parties. Para. Counsel for the parties have been heard, pleadings available on record have been carefully perused. The clause 25 of the contract agreement reads as under. A clause 25 is page 55, extract from a bare perusal of the clause as extracted above, it is revealed that the dispute, the resolution of disputes as agreed to by the parties are in two stages. Stop. Once the disputes are identified and raised by the contractor, the same is required to be referred to the chief engineer / CPM. Within 15 days of the disputes arising, request the authorities prescribed under clause 25(1), Roman 1, to refer the disputes to DRC within 15 days, along with a list of the disputes. Stop. The members of the DRC to be constituted under section 25 is also is a part of the contract agreement. The members are already identified and are specified as under page number 50, tolo 25 clause of teams on member as a liquid extract. But in terms of the contract agreement, clauses of the contract agreement, the petitioner raised the dispute and called upon the respondent authorities to refer the matter for placing before the DRC. Stop. The communication of the petitioner raising the dispute was received by the railway authorities on 30/11. Where is that? 3011?
It is a page, Lordship. Page 108.
108.
Please.
108.
By the railways at page, sorry, on 30/11/2022. Stop. As is accepted by their communication dated 1/12/2022, addressed to the petitioner. Stop. Therefore, in terms of clause 25, within 15 days from 30/11/2022, i.e. 15/12/2022, the respondents were required to refer the disputes raised by the petitioner before the DRC. Stop. Thereafter, the DRC was constituted with a third member who is a member other than the one specified in the contract. Stop. This was informed to the petitioner on 14 or 17th?
14.
14.
14/12/2022, requiring the petitioner to accept the constitution and appear before the DRC. Stop. The petitioner, by his communication dated 23/12/2022, objected to the constitution of the DRC with a member which is different from the one specified in the contract agreement, and refused to consent, give their consent. Stop. On the contrary, the respondents were requested to recall the constitution of the DRC and reconstitute again in terms of along with the members specified in the contract agreement. Stop. Thereafter, by communication dated 5/1/2023, the railway authorities reconstituted the DRC with the members specified in the contract agreement and intimated the petitioner. Stop. However, it is seen that from 30/11/2022, the petition respondents were required to constitute the DRC within 15 days, that is 15/12/2022, in terms of clause 25 of the contract agreement. Stop. However, the constitution ultimately was communicated only on 5/1/2023, which is well beyond the period of 15 days, well beyond the period prescribed on the clause 25 of the agreement. Stop. Therefore, in terms of clause 25 of the agreement itself, if the dispute resolution is unable to resolve the disputes within the period prescribed, the parties then either of the party within a period of 30 days from the date of receipt of the decision of the DRC or on the expiry of the aforesaid time limit, give notice to the chief engineer /CPM CPWD for appointment of an arbitrator in the prescribed format. Stop. The petitioner accordingly, by communication, by notice dated 8/2/2023, issued notice on the petition respondents, calling upon them to refer the matter for the resolution of disputes before the sole arbitrator. Stop. The respondents, however, declined to do so, and rather insisted on the matter being referred to DRC, since the DRC has already been constituted. Stop. since the matter was not referred to arbitration, the present application has been filed on the 11/6 para. Having heard the counsels and noticed the pleadings raised, pleadings before this court, and the submissions urged before this court, it is seen that the time period prescribed under clause 25 of the agreement was not adhered to by the respondent authorities for constitution of the DRC and referring the matter for resolution of disputes by DRC. Stop. Clause 25 itself of the agreement clearly provides that where the resolution or where the order of the DRC is not accepted by the party, or the DRC is unable to resolve the disputes within the time period prescribed, then the matter must be referred to arbitration, can be referred to arbitration by either of the parties. Stop. The period within which the matter is to be referred to the DRC is 15 days from the issuance of the notice raising the disputes. Stop. Even assuming that this 15 days is to be counted from the date of receipt of such a notice, the notice of the petitioner raising the disputes was admittedly received by the respondents on 30/11/2022. And in terms of clause 25, the dispute is required to be referred to the DRC within 15 days therefrom, which will expire on 15/12/2022. Stop. However, on 14/12/2022, although the DRC was constituted, the petitioner did not accept the said constitution on the ground that one of the members named by the said order is at variance from the list of members, which is clearly expressed in the agreement. Stop. Therefore, a communication was issued on 23rd of December 2022, requiring the petitioner respondents to recall the earlier order and reconstitute the DRC. Stop. In response to the communication, the DRC was finally constituted on 23.
5/1/23. Earlier
5/1.
Bring the earlier member, Lord. So one member from earlier committee.
5/1/2023. Stop. It is clear from the said communications that the period prescribed in the clause 25 has not been adhered to. Stop. Even assuming that the petitioner requesting the respondents to reconstitute the DRC in terms of the members specified in the contract itself can amount to a waiver of the time period prescribed in the agreement, however, the same cannot be treated to have a binding effect on the petitioner unless a consent to that effect is given by the petitioner. Stop. The contract is binding on both the parties, including the clauses prescribed. Stop. There is a clear prescription of the time period within which the DRC is to resolve the dispute. Where the DRC could not be constituted and disputes be referred within the specified time period, the subsequent constitution of the DRC, according to this court, will have no binding effect in terms of the clause 25 of the contract agreement. Stop. Therefore, it will not be open to the respondents at this stage to insist that since the dispute resolution prescribed under clause 25, which was required to be resorted to in the first instance by the DRC, not having been resorted to, the stage for referring the matter for arbitration has not been reached. Stop. Such contention of the respondents cannot be accepted in view of the clear prescription under clause 25 prescribing the specific time periods. Stop. Under such circumstances, this court is unable to accept the contentions of the respondents and has to, and upon giving its anxious considerations, has concluded that the prayers made by the petitioner are required to be allowed. Stop. Therefore, under the powers conferred under Section 11 of the Arbitration and Conciliation Act 1996, this court therefore appoints
A small amount is there, my lord, claim amount is small, so retired district judge. Maybe Chayadevi, Srimati Chayadevi may be appointed.
Srimati Chayarani Goswami as the sole arbitrator to resolve the disputes arising by and between the parties and thereafter pass appropriate awards. Stop. The tribunal will also consider all objections that may be raised by the parties regarding arbitrability of the issues raised. Stop. This appointment, however, is prospective till the time a written declaration is received from the arbitrator appointed by this order in terms of clause 12.1
Yes.
of the arbitration.
12.5 my lord.
12.1.
12.5.
Arbitration Act.
Fine.
12.1. Stop. Upon receipt of such a declaration by the prospective arbitrator, the appointment will be confirmed. Stop. Copy of this order be marked to the prospective arbitrator appointed by this court by the registry. Stop. The parties will also place a copy of this order before the arbitrator appointed. And the parties will appear before the arbitrator on (27th of February).
Yes. My lord, your lordship,
Therefore, thereafter be listed on 13th of March.
your lordship has used one word, railway authority. It may be corrected.
Railway, no, CPW. There are so many litigations against railways, so
Yes,
comes
yes.
by default.
Yes.
Yes. List on 13th
March.
of March.
For hearing, I think, seven.
Matter relates to lordship refixation and downgrading of the pay of the petitioner on the last month of his service. Here, lordship, there.
Where were we last?
Lordship had sought for some instructions whether his we are contending that his promotion, it is a promotion to the post of typist.
Hmm.
His contention is that it is a direct recruitment. Lordship had
Direct
asked me to get the information,
Hmm.
but we could not trace out any advertisement.
I have sought for instruction, Lordship. He has communicated to me that it was an appointment through employment exchange. And Lordship will see the order, other orders, other promotion orders. Other promotion orders to the post of junior assistant for a moment, Lordship will see page 55. Page 55.
On presumption, we can't proceed.
No, Lordship, it is clear otherwise.
Where is
Otherwise,
the promotion, where is the appointment order?
typist appointment is at page 30.
You are typist.
No, Lordship.
You are appointed as.
This order is under dispute. This is the order. I am saying this is a fresh appointment. And they are saying this is a promotion.
Page number 30.
30.
Ah.
I am saying, Lordship, I am reading this order. Subject to satisfactory police verification on character and antecedents and submission of medical fitness certificate, marginally noted persons are appointed and until further orders as typists in the office of chairman. Here, Lordship, it has 5 names. Out of these 5 names, Lordship, 3 names, serial number 1, 3, and 4. I have contended categorically in the writ petition. They are outsiders. They are from the open market. But serial number 2, Luku Kolita petitioner, and serial number 5, Komal Dekha, they are from the department. Their names were there in the employment exchange, so they had been called, they had participated. Now, Lordship will see the original order. I have typed the copy. Original order, page 30, it is more clear. To the candidates from the open market, these appointment orders have been sent to them in their residential address. Page 34, Lordship will see. Page 34. If they are departmental candidates, there was no requirement of sending it to the residential address. Serial number 7, Babula Chandra Das, it is to the residential railway colony, quarter number so-and-so. Serial number 8. Also, Rekharani Das, it is to her residential quarter. But for the petitioner, and even for respondent number, even for serial number 6, previous page 33, Chanakya Boro, village Doloipara, so-and-so. They are not from the department. They are outsiders who have participated in a fresh recruitment process. But 9 and 10, serial number 9 and 10, page 34, 9 and 10, Luku Kolita, Komal Chandra Dekar, since they are from the department itself, they participate in the fresh recruitment. These orders were communicated them, serial number 9, 10, through the office of the chairman AACP. Now, how a promotion orders the respondent department generally issue, that your Lordship will see in respect of my promotion order to junior assistant, senior assistant, superintendent. Lordship will for a moment look at my promotion.
You say it is a direct recruitment.
Direct recruitment.
They say it is a promotion.
They say it is a promotion. It is also because in a promotion, there will not be police verification, Lordship. There will not be character antecedent medical fitness certificate. These are there in case of a fresh appointment.
There could be. What is so
yes. Then they would have done in
shocking that for promotion police verification can.
Yes. Then they would have. Then Lordship will see his other promotion orders. Page 55, senior assistant.
Now neither of the parties you are able to give us any concrete documents other than attempting to give an interpretation. Now see, your communication, where is your communication? Your communication is sent through the office of the chairman.
Yes, because I was already working in the same department.
So by that you have been asked to report for duty.
Yes.
From the date of issuance of this order.
Yes.
So they may say that since you are already there, we consider this to be a promotion.
No, Lordship, if it is a departmental exam, it is a departmental exam for all the candidates. If it is a direct recruitment, all the candidates are to be treated as fresh recruits. I am not claiming.
All right. So now if you are a fresh recruit, then what happens?
If I am a fresh recruit, I am entitled to, and I was granted financial upgradation benefit on 1/1/2007.
Can we complete it by 3:15?
I think
with
so,
an order.
I think so.
No, you can complete. Can everyone complete, including dictating an order?
Dictating may not.
There is a
possible.
watch behind, isn't it?
Yes, I'm sorry.
So,
Dictating may not be possible, but
so we'll
hearing.
keep it on Saturday. You're welcome to join us on Saturday.
Saturday.
Yes,
Noted.
we'll try to complete it on Saturday. Because we don't want to keep it pending, otherwise I'll have to release it.
Let it be on Saturday.
You know? There may not be other hearing, I mean,
Yes.
pending matters. This matter and another matter I've already fixed. So we'll try to, you come up with whatever you want to rely on and we'll finish it off. The only controversy was that FR
That is the second aspect.
22.
No, first my financial upgradation taken away. For that FR is not connected.
Itu bono korise.
First my lordship financial upgradation taken away, which my